purchased the property of the whole total plot of the land he has purchased.
Total plot.
Total plot of land of the,
There is no co-sharer.
there is no co-sharer on that plot.
Show me that. Show me that you have raised that point, that there is no co-sharer in the plot of land.
My lord, kindly come to my lord. 34, I have annexed the
Page 34. Yes.
Page 34. Page 34, I have annexed that number, my lord. My lord, last but second, Turun Bhui.
Yes.
He has purchased the entire 0.0075 decimal. Got it, my lord? Turun Bhui.
Torun Bhui. Yes.
He has purchased, accordingly his name has been recorded. My lord, kindly come to my lord. Copy of the plaint. At page,
Show me that you have raised this point that there is no co-sharer. Where is that?
my lord, kindly come to my lord, ground number. Ground number 345. The court will fail to understand that the plot of land of a riot, as implied in section 9, the land thereby committed an. The court below has failed to understand that the riot Anil Chandra De sold or transferred his entire land.
No, his entire share. That's a different thing altogether.
His entire land, not share. His entire land, lying on that plot. His entire land lying.
Show me your purchase deed.
Purchase deed I have.
What is the foot plot? What is the plot of land?
My lord, kindly come to my lord, page 16. The page 16. This is the petition under section 8 made by the opposite party.
Yes, page.
Page 16.
16.
16.
Yes.
My lord, kindly come to my lord. Schedule Co and schedule Co.
Yes.
দলিল গ্রহীতা তপন ভুঁই স্বর্গীয় পিতা সাহেব ভারতীয় নাগরিক চাষাদি হেতমপুর পোস্ট. Next, my lord.
No, you have not purchased the entire plot, sir.
Yes.
No. Please kindly come to page 19.
Yes.
The total measurement of the plot of land is 15.5 decimals, and you have purchased 0.75, not the entirety.
0.75 is the total land of the first file.
That may be. That's the
similar identical issue has been considered by the division bench, not yet, that has not yet decided, my lord. Kindly come to my judgment that was referred to.
Have you brought the Supreme Court judgment, Chanarani Das?
There is a larger bench decision.
Sir, have you brought the Supreme Court judgment, Chanarani Das?
No.
There that point has been decided. Supreme Court has held, even if the entire share, where is the Chanarani Das? That was considered by the subsequently division bench of our court. Division bench presided over by Justice Aniruddha Bose. Show me that. And see the language of section 8.
Section, kindly, my lord.
Yes.
In this order, this is recorded.
Show me that in this
first page, my lord, the first page, 8, section 8, my lord. In the present revision application, question of right to preemption in case of sale or conveyance, the entire share of riot is involved, is relevant. Section 8 of the West Bengal Land Reforms Act 1955 here is the relevant provision dealing with the preemption. This section reads thus: right of purchase by co-sharer or contiguous tenant if a portion or share of a plot of land of a riot.
Yes. What does it mean? If a share, portion or share, so a portion of the entire share, it does not say that the entire share, if it is transferred, preemption will not be.
My lord, this
Show me the division bench judgment
This was-
and Chanarani Das.
my lord, already in our High Court and larger bench has been constituted. And that
Show
larger
me the
bench,
larger bench reference.
that larger bench not yet decided
No. Show me the reference, point of reference.
in this,
Yes.
My lord, kindly come to my lord, last. His lordship also considered the same, my lord, last paragraph, whether the right of preemption is available to a preemptor in the case of transfer or conveyance, the entire share of or entire portion of the plot of land of a co-sharer to any other person than the co-sharer riot.
Sir, have you got the judgment of Justice Bose?
My lord, this is
Division bench, that's the division bench.
that division bench. It is.
Yes. Show me.
Is it recorded? My lord,
Yes. Please kindly come to paragraph 22 of the judgment. This has been relied upon by the learned trial judge, learned judge of the first appellate court.
my lord,
Where is that judgment, sir? This is the division bench judgment. Considering Supreme Court Chanarani Das.
this is the latest position of the larger bench. It is not yet decided, but
Sir, division bench has
my lord,
decided
larger bench,
this. Larger bench constitution, how many judges?
three.
Show me the reference before the larger bench.
My lord, this is the
Show me the point of reference.
my lord, that position is. Oh. At, your lordship got second item 1306/2009. The reference I have handed over to your lordship.
This is
That is
written submit file.
written notes have been filed, but not yet decided finally. Not yet decided finally.
Where is the point of reference? Show me the point of reference.
My lord, your lordship, the first I have handed over the first judgment.
Yes.
Lordship got the CO number
1306.
1306 of 2009. That number is second number
Yes.
06 of 2009. Mayarani Hajra. Got it, madam?
The learned advocate appearing for the petitioner
My lord, child,
Yes.
I am for the husband. The child is under the custody of mother. My lord, page 9.
What is the order you are challenging?
My lord, my lord, interim order is violating by the mother, my lord.
Violating, you have to take steps.
My lord.
So which order you are challenging?
My lord, that's why, my lord, kindly give liberty to approach before the learned court below for regarding violation. There are,
Which order is being violated?
my lord, page 9.
Page 9.
My lord. My lord, middle, according to the petitioner to permit meet his
But what is the order you are challenging in this?
minor son. My lord,
Uh,
main contention
this
of the
application under Article 227 of the Constitution of India.
suit for eviction.
Yes.
And prima facie, my lord, the case is not very happy fact for me, my lord. The second default. But the thing is,
Second default.
second 7-1 application was decided, my lord, on the basis of an agreement. The parties agreed to a conclusion that this is the area of rent they are paid. In March 2020, and my lord, the agreed rent was from my lord, March 2019. The due rent was from August 2019 to March 2019. Thereafter, my lord, your lordship knows the police atrocity happened in Howrah Court, and my lord, the court was closed. That's why, my lord, the current rent could not be paid. So, my lord, thereafter, the moment,
Police atrocities happened till how much time?
my lord, thereafter, my lord, COVID came.
COVID came.
The
Police
COVID
atrocities went till how much time?
my lord, till December 2019, what I can recollect. Then, my lord, January, February, the time was there, my lord, no doubt, my lord. But that time, my lord, he couldn't contact with that. He was not aware of the fact that the cessation of work has lifted. My lord, then COVID came in 2022. The entire amount has been deposited within 151 application. That
What
was
can be
rejected.
done? Cannot be.
Lordship, kindly let me serve and come back here because your lordship kindly see the situation where there was the intentional latch on the part of the litigant. My lord,
Cannot be extended because
my lord, so far the Chamaria is concerned, my lord, relying upon a Chamaria, the matter was the Chamaria is not applicable in this case, my lord, because
Samaria is not applicable because here it's not a case that you have not applied within the time. You have applied within the time. 7-2 was disposed of, complied with. So it's thereafter you did not comply
my
with
lord,
7-1.
in April 2019, I went with the money, my lord. That is that I cannot have anything to show place in the record because 2019, our lordship knows very well the court was closed completely and no work was going on in Howrah Court, my lord. The normal litigant will not be able to know, my lord, when the court is opening and when the court is on cessation of work. Please kindly appreciate that. Let me serve and come back. I'm not paying for any interim or relief, my lord. Let me only serve
Show
and
me
come
your
back.
151 application.
That is at page 36. My lord, the paragraph number 4 onwards, defendant begs to state that after the said payment, the court was remained closed. And not that, my lord, I had any lack of bona fide. I tendered the amount, my lord, with my 151 application. The check was deposited. That was in the very next page. On the day of my appearance, I filed 7172 application.
7172, nobody is
Deposit.
disputing. Show me the finding of the learned trial judge.
Actually, relying upon a chamaria, my lord, that was rejected. That isn't done, my lord. And the other judgment which has been reported, I found this judgment on relevance in this case. My lord, relying on the last paragraph, your lordship will find defendant submitted due to COVID-19 pandemic, he could not deposit the arrear rent during the period, the last paragraph in the first page.
When you deposited the area rent,
Arrear rent I deposited, my lord, in March 2019. And
March to the, no. After,
that was
when did you file this
that was,
application? 151.
that was in March 3, 2022.
March 3, when
Yes.
the amount was deposited?
The first deposit.
No.
Now the check,
This-
my
yes.
lord, I have seen. The check is there, my lord. With the application, my lord, itself. My lord, that is at page 42. 2nd of April, the check. The application was taken out on March and then check was second.
No.
But
Not
that was
along
the first
with the
check. That was the first check. But with
Not
the
along with the
application,
application also.
my lord, yes, my lord, that has been deposited, my lord.
How can it
My
be?
lord, no, they cannot
Keep
accept
that second of it.
they cannot accept it. They cannot accept it, my lord. If I. My lord, kindly-
You said that along with
No,
the
no, my
application
lord,
it cannot
that
be.
I was instructed.
No, instructions will not help because the application was filed on 3rd of March.
Yeah.
Your check is dated 2nd of
That
April.
was the previous payment, my lord. That is the previous.
2nd of April.
That is the previous payment.
So where is that check? You have not.
My lord, that has been,
anything?
that you kindly take paragraph number 3, my lord. The defendant begs to.
No. You have not paid. You have not deposited that amount. Permission to deposit.
Our court will not accept my deposit, my lord. The first deposit, my lord. If your lordship can direct me, I can, my lord, present the check before the land register for my to show my bona fide, my lord. Even till today, my lord. And that will be about the result of the application, my lord. Otherwise, the court will not accept. I'm interim protection. I have don't.
You have said you do not.
No, I know what I have said, my lord. That. And I said, but then I.
What is the next date fixed?
The order hasn't passed long back, not that.
Order has been passed long back. You do not know the next date. I've kept it
No,
on
no,
12th of August.
the date which has been
Sir,
quoted
I've
here.
kept it on 12th of August. And you have started by saying.
No, my lord, I cannot. My lord, this is not the very happy
Once
fact.
it is admitted, you are saying.
No, my lord, no, I cannot. My lord. I don't have very loud voice to play, my lord. It was a
Yes,
usual pay a reap, my lord.
Number 5. My lord, a caveat has been lodged by on behalf of the my lord opposite party, my lord. Through my lord Sivnath Ganguly, learned advocate, my lord. My lord, copy has not been served, my lord.
Yes.
Caveat lodged, my lord.
Yes, what is there in this matter?
Matter is, my lord, the my lord suit for eviction of a licensee, my lord. But the my lord, the suppressing the real fact, my lord. The my lord, the petition.
What happened? What is the impugned order?
Well, impugned order that, my lord, the suit was ex parte, my lord. Initially, the petitioner
It was decreed ex parte, then order 9 rule 13.
order 9 rule 13 with
That
section
dismissed.
5.
With section 5.
Section 5, my lord.
Dismissed.
Initially, my lord,
That has been dismissed.
my lord, dismissed against the misappeal, my lord.
That has also been dismissed.
Along with, my lord, the additional evidence, my lord, order 41 rule 27, my lord, for the evidence of the medical practitioner, my lord. That was also, my lord, dismissed, my lord. My lord,
What is
give
there in this?
one day accommodation, my lord. I am paying 1 day accommodation, my lord.
The learned advocate appearing for the petitioner sub.
Lord, I have challenged the order dated 13 June 2025. Also, in this matter, petition of temporary injunction has been rejected by this landed trial court. Petition for the temporary rejection has been rejected by the landed trial court.
That order is under challenge.
That Lord.
How civil division is maintainable, sir? This application under Article 227.
Lordship, in this matter, I am appealing for the petitioner.
Please use the microphone.
In this case, your lordship, the order that has been challenged, it is about recalling. It has been passed in a miscellaneous application challenging an order which was passed ex parte. The order is placed upfront, your lordship. Now, the main grounds that I have taken out in this petition is, your lordship, that while recalling the ex parte order, the subordinate court has failed to consider the provisions of Order 9 Rule 13 and as well Order 3 Rule 4. The order may be looked into once, your lordship, if I may place.
Yes.
The petitioner, I am placing from paragraph number 2, your lordship. the petitioner wife filed the instant application under Order 9, Rule 13 CPC for setting aside ex parte decree passed in MAT suit number 103 of 19 on the ground that her learned advocate, Ms. Priyanka Bachar, did not inform her the correct date of hearing. So she could not take proper steps to contest the suit on relevant date. So the suit was heard ex parte and the ex parte decree was passed. The learned advocate for the petitioner wife submitted that there is no intentional latches on part such and such. Now in paragraph 3 is our submission, Your Lordship, that the learned advocate for the opposite party husband raised objection and submitted that Miss Priyanka Bachar was not the recorded lawyer in MAT such and such, and so the ground as stated is false. There is no sufficient cause to set aside the ex parte decree. Thereafter, Your Lordship, if I go to the next page, decision with reasons, that is page 3 of the order. Paragraph 7.
Yes.
It is rightly pointed out by the learned advocate for the opposite party that the Miss Priyanka Bachar was not recorded learned advocate for the petitioner wife in the said MAT suit. In reply, the learned advocate for the petitioner wife pointed out that her learned advocate, Mr. Anirban Das, was not a regular practitioner in the local bar, and so he verbally instructed Miss Priyanka Bachar to take steps on behalf of the petitioner wife, and so she used to take steps on behalf of petitioner wife on such and such. And resulting which date is 22nd July is posted for ex parte hearing. Now, Your Lordship, if I take Your Lordship a bit back in time, the suit was instituted in the year 2019. Since 2019 till 2023, there was no steps taken by the opposite party, citing several reasons, COVID, local resolution, anything. 2023, one Mr. Anirban Das filed a wakalatnama and prayed for time for filing written statement. Such was accepted. Written statement was filed. Thereafter, for examination, dates were fixed.
Date of examination was fixed. Show me that, Lordship.
The Lordship kindly comes to page 42. 42 is the order dated 30 January 2023, where the date for WS was allowed.
You have said the date of evidence was fixed.
No,
Show me that.
not date of evidence, Your Lordship. I'm coming on to that.
No, I heard it as the date of evidence.
No. For example, I'll praise Your Lordship.
Yes.
For filing of affidavit in chief.
Where is that? Show me.
At page 43, Your Lordship.
43. Which order?
The typed order, Your Lordship, order number 20, dated 29, 2023.
No, where is the a separate petition has been filed praying for time to file affidavit in chief. Yes.
Lordship.
But no date has been fixed for affidavit in chief by this order.
Your Lordship is on page 43, Your Lordship.
Yes, 43. What is the date fixed for filing of the affidavit in chief? You paid for time?
No. I didn't pray for time. Your Lordship kindly considers thereafter also at several instances, time was sought for the petitioner.
Petitioner is absent by petition praying for time.
Lordship.
Petitioner is you.
Lordship.
So on that date you are absent.
No. Like, kindly looks into the second last line. Opposite party files Hazira, but show cause has not been filed by the opposite party as directed. A show cause was issued because they were not appearing on repeated instances.
Yes, thereafter you are absent also. Petitioner is absent.
On that date I was absent.
Yes.
But in this date.
But in this order, no date has been fixed for filing of the affidavit in chief.
No. Now,
show me what was the date fixed for filing of the affidavit in chief. Show me, sir, that the issues were framed. When the issues are framed, what are the issues of
issues weren't framed, Your
Sir,
Lordship.
how?
Your Lordship, let me come into the point.
How can it proceed, sir, without framing of the issues?
After written statement was filed, again there was non-appearance on part of the opposite party.
Yes.
Show cause was issued against her. She didn't reply on certain occasions. Then a new advocate comes, files Hazira, didn't pray for time. Thereafter, another date. Thereafter, after a lapse of 1 or 2 days, she files the show cause petition. After show cause petition, when the case was again fixed for hearing on 2 consecutive dates, the opposite party doesn't appear. This has not been on 2 instances only, which has been
Sir,
recorded. in
can past conducts be looked into under Order 9 Rule 13?
Your Lordship, I'll get back into that. Kindly looks into the order, not about only Order 9 Rule 13, but the grounds that has been taken into. The ground is that my learned advocate has informed me of such a date.
Please kindly come to order dated 18th of July 20th of June 2024, order number 25.
Lordship.
So 18th of July 2025 was fixed only for framing of issues.
Lordship.
So it was not a date fixed for hearing of the suit.
Lordship.
So can on that date, 18th of July, an order can be passed that the suit should proceed ex parte, could not have been passed. It's beyond Order 9 Rule 6.
Your Lordship, that is not the point that
Has to be.
but kindly looked into the petition.
Sir, on that date, it could not have been fixed. It's violation of 227, everything can be looked into. So on that, so framing of issues have not been framed. On that date, it was not a date fixed for hearing, so it could not have been directed to proceed ex parte.
Your Lordship, but this order was not challenged by the opposite party.
Challenge.
What I am
asking you, giving you
what
I
I'm
am
giving
asking
you
you
is, Your Lordship, very well. But prior to that, kindly considers the conduct of the opposite party once. After that, Your Lordship is with me or without me, I am not onto that. The conduct is first, an advocate has filed a wakalatnama or memorandum of appearance. He is making appearances.
It's a matrimonial suit. Why are you shying away from a contested hearing?
We are not
Sir,
shying away. It has been 5 years. I am a individual serving in the defense. It is very
in the ex parte degree. I have gone through the ex parte degree judgment. I have gone through that.
Lordship, but then there may be a direction so that the same may not be hurried into. Kindly look into my constraints. The petition.
I will expedite the suit. I will expedite the suit.
But Your Lordship kindly records the wrongdoing, because one thing which I need to point
If you
out.
want, so I can stay that. I will hear them. If you want to delay your
Lordship
suit,
kindly does that, because kindly considers one thing.
Ashwin,
I am appearing for the petitioner, my lord. I have filed an application for expeditious disposal of the
what?
probate. It was initially filed on 7/5/2024, and till date the paper publication order is being done.
What is the stage of the proceeding?
My lord, the service is or on the last occasion, that is 10/7/2025, the acceptance of the service upon the relative was fixed.
What happens? It has been accepted. Then, Ashwin. this application under Article 227 of
Excuse me. Wait, please, my lord.
yes.
My lord, I pray appear on behalf of the petitioner. This is an application for expeditious hearing, my lord. My lord, be pleased to come to page number Roman 2, which is a short list of dates.
What is the stage of the suit?
My lord, final decree has passed.
Final degree also passed.
Order for survey commissioner. First survey commissioner was appointed 2020
Final degree passed, then why survey commissioner?
because this is a suit for partition.
You said final degree passed, a final degree
There are-
without commission out.
No, let me brief, my lord. What happened, my lord? The suit was filed around 2015.
Show me the order sheet, sir. Show me the order sheet.
Annexure P1 is the first order.
Commissioner filed its report.
Commissioner filed its report.
Yes. So it's the evidence of the commissioner on 6th of September.
Yes, there was a date which was prayed for written objection by the defendants. Thereafter, I will admit, which I've also written, the PO was not present because
This
of
application under Article 227 of the Constitution of India is at the instance of the, you are the plaintiff.
I am the plaintiff, my lord.
That the instance-
Legal heir of the plaintiff. The plaintiff expired during the proceeding.
Is at the instance of the plaintiffs praying for a direction upon the learned civil judge senior division first court at Barasat to dispose of title suit number 189 of 2015 expeditiously. Full stop, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite party. Full stop, however, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite parties or upon the learned advocates representing the opposite parties before the learned trial judge. First up, from the order sheets appended to this application, this court finds that the suit was decreed, that the partition suit was decreed on preliminary form on September 26, 2022. First up, thereafter the final degree proceedings started. First up, the partition commissioner submitted his report, and 6th of September 2025 has been fixed for evidence of the commissioner and for filing of the written objection in the meantime. First up, in view thereof, CO number such and such stands disposed of by requesting the learned civil judge senior division first court at Barasat to make an endeavor to dispose of the title suit number 189 of 2015 as expeditiously as possible without granting any unnecessary adjournments to either of the parties, keeping in mind that this is a suit for partition pending from the year 2015.
Much obliged, my lord.
Next.
That's a definite. Much obliged, my lord.
Next.
On behalf of Somati Biswas, I am praying for not this week because he is suffering from fever, my lord, I am told, my lord.
On the prayer of the learned advocate.
Adjourn. 10.
Item 11, my lord, I am appearing on behalf of the petitioner, my lord, being led by Mr. Ujjwal. Now, this is an application for expeditious disposal, my lord, of an application under Order 9, Rule 9. My lord, I am the defendant in the suit, my lord, filed before the learned trial court, my lord. My lord, what has happened here, my lord, is the petitioner, my lord.
Order 9, Rule 9, what is the stage of the proceeding?
My lord, it has been heard, my lord, but order is kept pending for last 6 months, my lord. And unless
19th of July was fixed for orders.
My lord.
What happened on 19th of July? What is the next date fixed? This application under Article 227 of the Constitution of India is yes, Mr. Richo.
Suit for eviction filed by my lord. Joint plaintiffs, my lord, both of them were died, my lord. What happened, my lord? The son of the plaintiff number 1 files an application for substitution that has been allowed, and he has become substituted plaintiff. And plaintiff number 2, my lord, died in the year 2018. My lord, in the meantime, my lord, substituted plaintiff number 1, he, my lord, files an application for expunging the name of the plaintiff number 2. That is, my lord, this is plaintiff. That has been allowed. Thereafter, my lord, without filing, my lord, 7 years after the death of the plaintiff number 2, my lord, without filing any application under Order 22, Rule 3(1) or 2, or read with Rule 9, my lord, the plaintiff, the legal heirs of the plaintiff number 2 files an application under Order 1, Rule 10(2) for addition of their name as pro forma defendants. We are completely bypassing the code of
The issue.
number 1 against the defendant.
That can proceed. No difficulty in that. Suit should not be stayed. Let that proceed. Pro forma
For
defendant.
limited period, may not kindly stays the suit. For limited period.
For what?
For staying
The stay I have given for limited period till December.
The stay of the proceedings of the suit.
No, no, no. Let the suit proceed. Eviction suit, any of the co-owners can file a suit.
Yes, yes.
Not necessary that all the co-owners have to be joined. So it can proceed. Yes, next.
Sorry, my lord, I am for the petition.
Yes.
Partnership.
My lord, application for payment of the balance consideration amount in a suit in an application for preemption has been allowed at a belated stage. Against that, my lord, I have come up. At the time of institution of the,
What happened to the preemption application now?
nothing, my lord, the date has been fixed, my lord, for payment of the balance consideration.
When the preemption application was filed?
2019 March,
When this application was filed?
this application,
The application for payment of the balance consideration.
2022.
2022. Ashun. By the order impugned.
Able to do anything with this property. I will not be able to do anything with this property.
Why?
Because, my lord, the matter is will remain pending. Now, my lord, if the short deposit, my lord, if it is barred, then, my lord, whether it is entire share or part share, my lord, the application is not maintainable. That was my humble submission, my lord. But if your lordship, my lord, kindly,
What will happen? Nothing will happen.
well, I will not be able to do anything with this property.
What you will do? When the preemption application is pending, you will transfer.
Well, that is the reason, my lord, I am eager to get it hard.
Yes, yes, it will be hard.
Well, kindly appreciate.
Let the larger bench issue be
Larger
decided.
with
Otherwise,
regard to the entire share,
Well,
even if he has a case with regard to the merits of as regards entire share or part share, well, if it is a short deposit, well, then he is not. He has
that
no,
is why I am saying short deposit.
well, he has no case. So in that event, my lord, if your lordship keeps it pending, your lordship knows, my lord, the consequences. My lord, I will not. My lord,
Motion September monthly list.
develop.
Yes.
My lord, this much.
Thank you. Yes. Who is appearing? None appears for the petitioner at the time of call. You are appearing. Yes, next. Grateful man.
Item number 16.
Item 16, my lord, I am for the petitioner, my lord. When a
Yes.
petition has filed this petition for expeditious hearing of this execution petition, my lord.
Execution petition.
My lord.
Any miscus pending?
My lord, only execution petition is pending, my lord.
No miscus pending?
No, my lord.
What is the stage of the execution case? Have you taken steps? 5th of June, you are directed to take steps by the decree holder. Have you taken steps?
My lord, steps has been taken, my lord.
This application under Article 227 of the Constitution of India is at the
I'm for the petitioner. Only
Yes.
visitation rights of the father of the girl child, my lord. Act 8 has been filed. Will kindly come into the page number 8 of the petition. My lord, petitioner is a natural guardian of the father. Filed the Act 8 case.
What is
Right.
the stage of the
My lord,
Act 8 case?
my lord, they have not appeared. I have served the copy, but they have not appeared in the case. But my visitation is not giving. The wife has already living in another person. She is not. She is absconding, my lord.
Where is your application?
My lord, application in the last annexure.
Page?
Annexure 43, page 43, annexure P4.
So this is the main application. Where is the entry Where is the interim prayer application?
My lord,
Where is
kindly
the
see the,
visitation application?
kindly see the order.
No, application. Show me the application, sir.
My lord, application is not annexed here with. But the
Where
order
is the application for visitation?
my lord,
Have you filed any application for visitation? No.
yes, my lord, I have.
Where is that?
I have filed, but that has not been annexed here with. But the order itself, kindly see the last, the order impugned.
Yes.
Kindly see the last, my lord, the order.
Yes. So in the interim, without hearing the opposite party.
Yes, my lord.
Yes.
Yes, my lord. But I have served the copy, but they have not appeared. Several
Six steps there.
dates are.
So this order cannot be passed ex parte.
My lord, I have.
I will give you liberty steps before the Learned District Judge. This application. Yes.
It's a otherwise a very short point is involved. But I am an executor under a will. I go and file a probate proceeding in 2019.
Yes.
The will is dated 2009. The opposite party, my lord, was a trustee under a trust created by the testator prior to his death and prior to the execution of the will. Now, my lord, before execution of the will, the testator had revoked the trust and had communicated such revocation to the trustee, and thereafter executed the will in my favor. Trust was in favor of the opposite party,
What is the impugned order?
in the impugned order, my lord, it has been held that in my application for grant of probate, that the opposite parties have covetable interest because of that earlier trust. That is the impugned order. My application for grant of probate has been held to him that contentious cause and not a non-contentious cause, and I have been asked to prove go for regular trial. That is the impugned order, my lord. But I would not request Lordship take it up tomorrow if Lordship permits, because I have to cite 3 judgments. The physical copies have not reached court. This is the point, and these are the facts. I believe my learned friend would not object to the factual facts that I have, factual position that I have not indicated.
Only one objection: the trust is an irrevocable trust.
Maybe that's a point that Lordship would decide.
That has been recorded in the order.
Yes, but I will show the statute permits.
Application was returned.
Yes, I would show the statute permits that this kind of trust can be revoked at any stage according to the wish of the testator.
On the prayer of the learned advocate appeal for the petitioner, As for,
My lord, for stay of execution proceeding.
accordingly, the applications also stands. Yes,
Well, I am the executor, is the petition before lordship. Whether, two things before I start, my lord, whether I am refusing to grant order of injunction, refusing to grant an order of injunction in probate proceedings, whether it is revisable or appellable. Because, my lord, so far 19 CWN, if you logically consider, it says that it is not a suit. So any order passed is the power exercising in a jurisdiction. Then 151 will apply. But it is my duty to point out to your lordship 299 of the Indian Succession Act. Any orders passed by the district judge. So taking to both, my lord, now my lord, I am moving this application because it is my duty to point it out to your lordship. After
299. Do you have? देखिए इंडियन सक्सेशन एक्ट to देखो.
Yeah, hand over to your lordship.
পেয়েছেন? পাননি? পেয়েছেন? হিন্দু না ইন্ডিয়ান.
Indian.
If it is in accordance with that,
Subject to the provision. That is the word subject to question, my lord.
shall be subject to appeal.
No,
To the
the
High
power,
Court.
the decision exercising power under this act.
Yes, made by district judge by virtue of the powers
Conferred.
hereby conferred upon him.
So this is, my lord, whether that is why we are considering the same, my lord, 19 CWN.
Do you have that?
Those judgments, it's because I'll say, your lordship, my lord, this argument was advanced to another banks. Adjourned, kept it for orders after, kept it for orders after that it has not been delivered.
What?
This same point arose in another proceedings, whether one not can you consider injunction continue matrimonial proceedings.
There is a decision.
That I am borrowing that analogy for the purpose of this. Whether my lord,
No, there is a distinction, Mr. Rai, in that. In
any order.
No, in a matrimonial, what are the appellable orders?
No.
It does not say as subject to appeal under Civil Procedure Code. Because under those Hindu Marriage Act or Special Marriage Act, whatever is that, you will find certain categories of orders have been made appellable, not all.
25
Here it's the distinction 299 says, all orders by the district judge
that's
shall be
subject to. Now, my lord, that is why 19 said it is not an order which is the order of injunction and other things. Allied order is not a suit, not a proceedings under the code of procedure, regular suit.
Where is that?
19 CW page 205, my lord. I do not have. Well, it requires I'm not on that it cannot be done, but it requires consideration from your lordship. This point required to adjudicate it.
Why have you not insisted the matter? You have said that it was for orders.
After that, it is beyond our capability. Yeah.
What is the impugned order?
Now, one can consider the rejecting my application for granting or ordering injunction. Even on last page, it is evident. One got it. Last page of the order impugned.
Last page, it is evident from the record.
It says that the Peter mentioned the Kamala died on such and such, but till yet no death certificate has been filed. There is no dispute about the same. Their objection, it is admitted, she died. But till it is also emerged as a record, the will probate case has been filed on 24/4/19.
In a probate proceeding.
Yes, that's
concept of injunction.
Yes, my lord. What is followed from your lordship? The earlier portion. This is not a degree and other things. That was discussed. Apart from
this is that judgment where it has been said that decree need not be filed. Yes.
Because why it has not been granted, what are the procedure, it was held.
That is decree need not be.
Yes, why it is decreed in to file it? This is, and injunction can be granted for these, those judgments are there. My lord, can you consider bill order? Keeping aside all the other judgments, my lord, where this all honorable court is. The court held the proceedings for grant of probate of letters of admission is not strictly a suit, a formal degree. So that is why, my lord, why I am arguing that it is not suit 39(1) and 2, because 19 CW categorically held that it is not a suit, and civil procedure code in that sense will not apply for the, because granting of appeal is a statutory right, my lord, can you consider, unless until it is expressly conferred upon the parties.
Lispendence is there, Mr. If the lispendence is there,
My lord, can you turn to paragraph 10?
10 of,
This judgment, 299, what is fallen from your lordship, my lord?
no, which judgment? This,
I have handed over to your lordship, my lord.
yes, this judgment, paragraph 10.
Paragraph 10, your lordship.
Yes.
If order 43 rule does not lie, my lord, then whether, my lord,
No, it says it does not include an order for a grant of probate.
yes.
So it was considering that when the grant of probate is neither a degree nor an appellable order. But here is the case that injunction, whether it will come under order 43.
If you logically consider is appeal from the order, provisions of the appeals against the order, paragraph 15, my lord, your lordship, can you
Yes,
consider?
yes, I am at paragraph 15.
Appeal order contained in order 43, order 43 of the code. It enumerates the orders against which an appeal shall lie, does not include the order grant of probate. Therefore, question may arise whether an appeal lies or at all, or not an appeal against an order. In case of such and such, an appeal was prepared against the order rejecting an application for revision. Point was taken that the judgment directing rejection of appeal amounts an order only to that. An appeal would lie against that order only under provision of 588 of the Code of Civil Procedure. The contention apparently was based on the fact that the 86 of the probate and administration. Well, that was the provision was just considered earlier. 16,
Paragraph 17 is the answer.
yes,
It says it is instituted by not a plaint, by a petition.
yes. They commenced on an application or a petition. It commenced. The decision appealed against the describing 299 is an order and not of a degree. Therefore, it held the decision of a court in a process of data administration is a degree. In coming to decision, reliance a place such and such. It is observed the suit is already instituted by the president of
It's not strictly a suit. If it is not strictly a suit, then order 39 rule 1 and 2 that appeal provision or larger bench comes into.
So this requires consideration, at least something appealing to your lordship for the purpose of adjudication. Well, where we will go? We need some court to decide all these issues. Then we are also related to argue in this matter. Otherwise, we are not.
But that is one, and list pendants, if the list pendants you are protected, Mr.
Then why multiplicity? Put this question to myself. Then what is the phrase for using avoid multiplicity of proceedings? Dispatches is there. If it transfer, why multiplicity of proceedings? There is no order of rejection. You can deposit into any matter. If that is the concept of dispatches, my lord knows.
Now, Mr. Rai, only one thing, this was an ad interim stage. So
No,
now, yes, service of notice, what happened? So from now, you are,
my lord, if this is the scope, but I could have understood. I failed to get privacy case and other things.
that is, but it's
And then
more than 1 year. Have you served notice?
yes, that process is there. My lord,
Then I'm,
they have admitted they are transferring. They have admitted.
no, it was at an ad interim stage.
My lord, can you consider
So,
internal page 2?
oh, injunction order has been, injunction application
It
has
has
been
been rejected.
rejected.
Whereas the learned advocate for the objector, my lord, internal page 2, my lord, you logically turn to the internal page 2.
What is the fate of the proceedings before the learned trial judge? Before the district judge?
It is pending. That is that
So pending at what stage?
that stage. But then, my lord, I have to come back with the instruction, my lord. What is the stage at least?
Serve, let them come.
At least protect the property, my lord.
Nothing will happen for more than 1.5 years. You are without any dispendence is there.
It's very, my lord, can you consider? If I have
Consider that let them come because ad interim after so much of time, Mr.
my lord, I have filed. I have. It is not that I have not tried to move this. My lord, can you consider when it was filed? 2024. The order.
The issue of maintainability is also there. Let me see.
That is why. That is why it is a big case to protect the property. My lord, can you consider?
The
It's the reason for assigned for the purpose of rejecting.
taking it as motion. You know,
They have admitted they are transferring. They have said, according to our share, we are transferring.
where is that
Yes,
admission?
can you turn to the objection they have filed? Page 53.
No, they have filed objection also.
Yes, yes. Page 53.
53. Yes. Which paragraph?
Paragraph 9.
Never tried to transfer.
The opposite parties are looking after the
Paragraph
9, page 56.
Yes, on the contrary, are looking after the property, taking advantage to disturb in view of this, the office never tried to transfer.
Mother, can you don't go by the underlined portion? Mother, can you consider the entire paragraph?
You have underlined for the court to take note of that. Never tried the attesting.
Never seen the alleged suit property. Be it is mentioned here, the opposite party never said.
But transfer they have denied, Mr. Rai. It's you have said that they have admitted that they are transferring in their share. No, where is that? They have
Yes,
not
that the
admitted.
property alleged to have been mentioned in the
Denied that.
is
Never tried to transfer.
in the locality, and this opposite party are owner of 911 share, and they although no third party never encroached or possessed any
Yes.
portion of the it's so transfer or sell out of any portion of the part the property is foreign to the any
property so that
so
the advantage may not encroach or possess any property. Nothing. Serve them.
and record the in view of this statement made, my lord is not passing any order of injunction. In view of this statement made, my lord,
That is the learned district judge. Then I can dispose it off. I can dispose it off.
while directly to serve copy, my lord can record that so I can. It is their statement, my lord. I am taking as a truth that portion will be granted to me, and keeping the amendment point open.
By the order impugned, an application under Order 39, Rule 1 and 2.
Injunction, my lord, record injunction, though it is captured on 39, 1 and 2. My lord, whether my lord will an application for granting our order
By
injunction.
the order impugned, an application for This is your book.
Yes.
Yes, Mr. Rai?
Oh, this is the people. This is the point because consideration, because something may not any order, then one granting an order adjournment. That will be available. 299. Any orders?
No, adjournment is a different thing. It does not fall. The question arises.
Any orders?
Yes,
Then any
because
order-
if it is finally decreed, final order, then it's applicable, no dispute on. So the question might arise with regard to
amendment application for
applicable orders. Or yes, other interlocutory orders which are neither decree nor a
appealable under, but then all the orders is subject to appeal. One can consider in other way.
in another matter, not in this matter. Yes, next.
Lord, I am for the petition and in this matter also I have to check, my lord. It is pending before the learned civil judge Baripur.
2 p.m. Next.
Grateful.
Item number 22.
None appears for the petition at the time of call. Yes.
There is a
Yes.
this. This is an application, my lord, wherein I have filed an application for against the order, my lord, issuance of warrant of arrest, my lord, by the DCDRC Nodia, my lord. My lord, the issue is that, my lord, despite being filing an application, my lord, wherein the intimation regarding Honorable Supreme Court's order that the payments regarding the Shahara credits will be disbursed by the government portal, the DCDRC Nodia is not hearing that application and continuation with the warrant proceeding, my lord.
What is the order under challenge?
My lord, the order, my lord. Warrant of, my lord, page 41, my lord.
No, 6th of October 2023.
Yes, my lord.
Where is that order?
My lord, this is the page 41, my lord, that of the order. My lord, I have filed an application for, my lord, for recalling.
Who are you? You are the judgment debtor.
Yes, my lord, I'm the judgment debtor, my lord. My lord, I have filed an application for recalling of warrant of arrest, my lord. As my lord already by
You filed an application for recalling of this order, 6th of October.
My-
What happened to that?
My lord, that application is still pending, my lord. They have not hearing, my lord, and continuously, my lord, it is only being recorded as that warrant of arrest being continuous, my lord.
So why are you not appearing? Appear,
My lord,
make
the
your
only-
submissions.
My lord, the difficulty is, my lord, that application has not been numbered yet also, my lord. Though I have filed that application, my lord, and my lord, that application is,
Unless it is numbered, why it is not being numbered?
my lord, that is only, my lord, the only.
No, then there must be something. You have to mention the matter before
My lord,
the.
I have mentioned, my lord, but the learned DCDRC, my lord, is not considering, my lord. This is the last order, my lord. And due to thereafter no quorum on for a very long period, my lord, the matter is still pending, my lord. And my lord, moreover, the fact
Where
is,
is the application? Which application you have filed? Where is that application?
my lord, I shall come back, my lord. I think, my lord, the application was.
I give you liberty to move
Yes,
that.
yes, my lord.
The Yes.
Your Lordship, the husband petitioner had filed an application for divorce under the Special Marriage Act. Your
This is
Lordship,
the impugned order.
Your Lordship, the impugned order judgment is dated 30th of January 2024, which is at page 32, Your Lordship.
30th of January 2024. Yes.
Your Lordship.
Suit has been dismissed ex parte.
Your Lordship.
Thereafter,
Your Lordship, I have preferred this application.
how a civil division application is maintainable if a suit is dismissed?
Your Lordship,
Now it's an appeal lies against that order. This application under Article 227 of the yes.
This is the suit for partition, my lord, and the petitioner is the
I am
defendant in
opposing
the.
prayer.
No, I am coming against the order of order 6 rule 17 which has been allowed in court below, and that is order number 9, my lord.
What is the suit for?
Suit for partition, my lord. The suit for partition, my lord, and they have amended everything, my lord, in that particular suit that I have mentioned in paragraph 7, my lord. Paragraph 7 of my application, my lord. They have not only they have amended the prayer portion, the schedule, and number of paragraphs. Paragraph 7, my lord, of my application.
What is the stage of the suit?
Stage
No,
of this.
they have not filed any retestament till date. 3 years has gone, no retestament.
What is the stage? Trial has not commenced.
Trial has not
filed.
been. Trial has not.
Where is the application for amendment?
Application of page number 18, my lord. Page number 18. Paragraph 3, they have mentioned whatever they have amended. আপনাকে নোটিশ নোটিশ দিয়েছেন?
কপি দেবেন আমাকে, তো কপি ছিলাম, কপি
দেবো কেন? এটা তো ফার্স্ট টাইম অ্যাপিয়ার করছে।
কপি দেবে না,
হয়
তাইলে কপি দেবে না?
হয় কপি না। This amendment is changing the nature and character of the of the plaint, my lord.
Where is the plaint?
The plaint is on page number 9. Page number 9. And they have incorporated some new prayers as well, my lord.
Anything more? This application under Article 227 of the
Item number 26.
Your Lordship, I appear on behalf of the petitioner. I am seeking for an adjournment. The matter is appearing in the list after a really long time.
Opposite party, my lord. My lord, kindly have a look to the order itself, my lord.
Yes.
My lord, the suit was fixed for, my lord, ex parte hearing due to, my lord, filing of 7172 application after lapse of 2.5 years and also written statement. My lord, no payment has been made, though the application was filed after lapse of 2.5 years. Still, my lord, no payment has been made accompanied by that application. My lord, kindly say suit was fixed for ex parte hearing. Not only that, the 773 comes into operation, my lord. It is observed, my lord, by the court below. My lord, kindly have a look, my lord. And suit is fixed for passing, my lord, judgment. Hearing has been held, my lord. It is ex parte hearing, it was taken up. My lord, kindly have a look, my lord. When, my lord, he filed application 7172 and when 16/11/2021 first appeared in the suit. And my lord, 8 June 2023, 7172 filed. In between, they also challenged by filing application under Order 7 Rule 11 of the Code of Civil Procedure. That was, my lord, rejected. Thereafter, 227, Article 227 before this Honorable Court, that was rejected. And they filed lastly, my lord, on 8 June 2023, the 7172 application. There was no cogent reason, my lord. What is the cause of filing this application at the lapse of more than 2.5 years? For that reason, learned court below rightly held, my lord, in view of my lord Vijay Kumar Singh's case, my lord, that maximum it can be, my lord, extended as 7 to 2 months after passing the order of the 7-2 direction. So here, my lord, more than 3 months, about 3 years, my lord, without any cogent reason. Yes, sir.
Your Lordship, I am being led by Mr. Shomavo Ghosh in the matter, but
Madam,
if I may
please,
indicate,
no,
if
please
I-
proceed or I will pass an order.
if I may indicate, Your Lordship, I have rented this premises and I am running a water drinking kiosk on the premises,
Yes.
which is made in the memory of my dead grandfather. Your Lordship, the delay I would be able to explain if I am given the chance to show the delay with a list of dates. So, which is why I'm seeking for a very short
No, no, no.
adjournment.
This matter was adjourned at your instance on several occasions.
Yes, sir.
Your Lordship, but talks of settlements were going on, which is why the matter was adjourned.
Please
They are
proceed.
coming forward.
Please proceed, madam. Please proceed.
In that case, may I seek for a short passover, Your Lordship?
Yes.
Much obliged, Your Lordship.
Come at 1.
Much obliged.
I don't
Praying for not today, my lord.
I am for the petitioner in this matter.
Yes.
Your Lordship was, the matter was taken up, and your Lordship was the petitioner is the officer in Indian Army. What is happening in this matter? An order was passed on 14th of March 2024. That is at page 11.
Yes.
By directing, my lord, this honorable court, transferring the page 12, the operative part, under such circumstances, the application is allowed. The court is directed by the learned district judge, Paschim Medinipur, to transfer the records to the case record to the learned district judge Nadia. That is order on passed on 14th of March 2024 on the basis of the application of the wife. Then after you also kindly see the impugned order. On 2nd of April, the order was passed. But after passing of this order, the earlier court passed an order with regard to the maintenance. I am challenging that order on the ground that when the Honorable High Court is directed to transfer the case on 14th of June, thereafter on 2nd of April, the order was passed by the earlier court. That
No. When the order for transfer was passed?
14th of March, page 11. And impugned order, that is at 2nd of April.
No, but this 14th of June,
The 2nd of April.
2nd of April,
Yes.
you appeared.
Well, that was what this is the judgment was passed not on that date, my lord. Subject to
Judgment was passed. When the hearing took place? When the hearing took place?
no, before the passing of the judgment, my lord, subject to correction, but before passing.
No, that is prior to 14th of March or after 14th of March?
The application was filed on 19th of February 2023. 19th of February. For section 24 application.
Yes.
That was filed on 19th of February 2023.
Yes.
Now, my lord, thereafter,
When this hearing took place,
thereafter,
that is prior to 14th of March 2024 or after that?
my lord, what has happened only also kindly on 19th of December 2023. My lord, the application under section 24 was filed by the wife.
Mr. Bhattacharya, my specific question to you is, according to you, 14th of March 2024, an order of transfer was passed. My query, when I asked you that on 2nd of April 2024, it was heard in your presence, you said it was hearing took place earlier. When the matter was heard,
That is all I have to take instruction.
what instructions, Mr. Bhattacharya? Last occasion also it was adjourned for.
No, last one adjourned on the ground, my lord. I said that I am paying, my lord, 14,000 per month. My lord, they denied that. Your lordship are directly the opposite party to produce the document where whatever your allegation. But kindly see your lordship's order.
14,000.
I am paying 14,000. Yes.
I have no instruction, my lord. Kindly please another date.
It is not, my lord, that I am not paying the 14,000. I am paying 14,000. The application was itself filed section 22 application 19th of December 2023. After 1 month, they filed an application before this honorable court for transfer of that application. You will also kindly see the 19th of December the application was filed of 2023 and the order was passed by this honorable court on 14th of March. After the filing application, they came before this honorable court for transfer. On their application, on the civil division application. And this court, my lord, is allowed for the application on 14th of March.
It has been transferred to which court?
My lord, from Paschim Midnapur to Nadia.
All right. So I'm setting aside this. I'm directing the transferee court to decide the application afresh.
Kindly pick another date.
This application under
So kindly, my lord, he is one advocate.
ভট্টাচার্য লার্নেড অ্যাডভোকেট, ওই যেটা বলেছি না, ওই অন ইনস্ট্রাকশন করে দেবেন ওই, হ্যাঁ ওই যেটা ওই 14,000 টাকা যেটা বলেছে অন ইনস্ট্রাকশন। Yes, call the next matter. Mr. Bhattacharya, what is the can for?
My lord, can was disposed of, my lord, because can urgent.
কথা বলতে হবে।
And 1 of 2024?
Can for expeditious disposal.
এটা আমার ইনফরমেশন ছিল।
When it was disposed of?
এটাই কেন?
No, can for appropriate order. Well, that was
Can stands disposed of. In view of this order passed in the next.
Number 28.
Yes.
Lordship, this is an application for expeditious disposal of the matrimonial suit presently pending before the learned additional district judge at Bolpur. Originally, the case was filed in the year
What is
2020.
the stage of the suit?
My Lordship, evidence has been taken on the part of the petitioner and has been next date has been fixed on 11th November 2025.
Any alimony
No,
order has been passed?
no, my Lordship. Only one thing, Lordship, I want to take kindly come to page number 41, my Lordship.
Page 41.
41, yes.
Yes.
Lordship, in order number 5 dated 25/1/2024, the last order on that page.
Yes.
Yes, Your Honor. Lordship, when this reconciliation has been failed, subsequently, this is a dilatory tactics availed by on the part of the respondent to delay that. On the next order itself, in page number 43, again a petition for reconciliation has been filed on that ground. So, one after another
This
application is filed.
under yes.
Lord, item number 29, I'm for the petitioner, similar matter, my lord, for expeditious disposal. I'm for the husband, my lord. I have filed one petition for dissolution of marriage under Special Marriage Act in 2017. Thereafter, my lord, one miscase was filed under section 36 for asking me for pendant light. maintenance pendent like my lord. So those cases are pending since long, my lord.
This case has been disposed
No, my
of.
lord, no, my lord. Both are pending in 2023. I had already
Next date fixed in the miscellaneous case.
my lord, on the next 24/7. I oblige, my lord. On 9/8/2025 for the mat suit, and my lord, miss case is 7/8/2025 for further arguments. Now, my lord, the problem
is for argument on 7th of August.
Yes, my lord, but the problem is on 23rd, 2023, I had already approached under Article 227 on Honorable Justice Shampa Sarkar, and order was also prevailing, which came on 26 2023, saying that the miscase must be disposed of within 4 months in 2023, and the
What is that order?
my lord, 20th June 2023. If your lordship kindly comes.
Where is that order? Which page?
My lord,
have you annexed that?
Yes, my lord. Yes, my lord.
Which page?
My lord, it's P3, my lord. Page number. It might not match. My lord, it's 23 in my.
This application under Article
my lord.
220.
Yeah, I am.
My lord, he may be granted to add some, the defendant. My lord, I am the defendant petitioner in this case, my lord. Some of the defendant challenge the order, my lord. Other have not been made parties by mistaking, my lord. He may be granted to add the parties, other defendant in that.
I could not follow. What do you say?
My lord, I am for the defendant petitioner, my lord.
Yes.
The defendant challenge the order. And some of them not challenged, my lord. They have not been made party in this application.
Yes, yes. What is the impugned order?
They allow the application order 26 rule 10A, my lord. Kindly
Yes,
come to
order 26 rule 10A for appointment of
Commissioner, my lord.
commissioner for what purpose?
Harmed impression,
Harm impression. At what stage, sir?
argument stage.
Argument stage. Yes.
The time of argument, my lord, kindly come to the evidence, kindly come to the page 37, my lord, last portion. The evidence of the.
What is the date of the impugned order? 26th of February 2024.
Yes, ma'am.
So that has been allowed.
Yes, application allowed.
Yes.
At the argument stage, my lord. In the evidence, my lord, the PW1 stated that I shall not pray for any handwriting expert in respect of the disputed deed. Not a fact that I have filed any suit for take back the possession of the suit property. I filed a suit only for against the deposit. They have not prayed for any application for send the it to the handwriting expert, my lord. But at the argument stage, my lord, when evidence completed stage of argument, they filed this application. And that application is my lord.
Show me the plaint.
Page 14.
Yes, where is the application? Where is your written statement?
Page 29.
Yes, where is that evidence? You have said that they have admitted.
Page 37. Last portion. Third line from bottom. I shall not pray for handwriting expert. Page 37.
37.
Of examination of proceedings of PW. PW1.
PW1.
12th August 2016. Last portion.
12th August 2016. Yes.
Third line from bottom.
Where is your evidence? Your evidence is completed.
Yes, yes. Suit is
Where
fit
is
for
that?
admission.
Where is that?
Yes, evidence I have not annexed, my lord. In the order, see, I have annexed the order thing. The suit is has been fit for argument.
Yes, what is the difficulty? According to you, this deed was validly executed. Let the examiner examine that.
At the time
That will
argument,
come.
I brought on.
I'm expediting this.
I have
You are concerned with the delay. I'm expediting this.
judgment, my lord. Honorable group of my. The delay to take cannot be. 3 and 11. my lord.
Paragraph
3 and 11. Paragraph 11.
Here, what happened? The rent receipts were sought to be.
My lord, come to page 50, my lord. In my application.
No. In this matter, the rent receipts, the signatures were sought to be compared by way of handwriting expert.
This is the thing. What you compare the handy. Some people think genuine. No.
Anything more? Anything more? This application under Article 227 of the Constitution.
I have filed one title suit before the Alipur court for ejection of the respondent.
Yes.
This suit property belongs to my mother, who died after making a will.
What do you want?
I want expeditious hearing, Your Lordship. This
What is the stage of the suit?
argument since 2021. Stage of argument since 2021.
This application under Article 220.
To appear for the my lord plaintiff, decree holder, opposite party and petition. Now, my lord, I prayed for expeditious disposal of Jamie's case number, my lord, 23 of 2018.
What is that Jamie's case for?
My lord, Jamie's case is for because initially I got expertise decree and judgment. Then I filed an execution. Immediately opposite party, my lord, defendant and judgment debtor, my lord, appeared and filed order 9 rule 13. Initially that was.
That is the order 9 rule 13 is the Jamie's case.
Yes. Now, my lord,
What is the stage of that Jamie's case?
Further PWs, my lord.
For?
PWs, further PWs, my lord, page 26. Last order, my lord, I have not annexed, my lord. I have my mobile, my lord, the server copy. It says next date is on 12th August 2025 for further PWs. And initially, order 9, rule 13, my lord.
For further PWs?
PWs.
What is the date?
12th August 2025. My lord, order 9, rule 13 proceeds. Then when we received someone, we pointed out
this application under Article 227 of the Constitution of India is at the instance of the decree holder
matter, I have been requested to pray for 2 days accommodation on behalf of the learned advocate for opposite party.
Opposite party, where is the petitioner?
Your Honor, the petitioner is also on the same footing. He's suffering from illness, so I have been instructed to pray for an adjournment also.
Who is the learned advocate?
Dulal Dey.
Mr. Amol Kumar Banerjee is appearing for the opposite party. My lord, he is suffering from fever.
On the prayer of the learned advocate.
Well, 34, my lord, I will not press that because suit has already been dismissed as non-prosecution.
The learned
My lord, I appear for the plaintiff husband in this matter, my lord. Match suit of 2017 under Special Marriage Act. The wife files an application under Section 36, which, my lord, an order was passed on 9th of December 2021. From that, my lord, both the husband and wife preferred the civil revision, which was thereafter, my lord, set aside with certain directions. It was remanded for fresh hearing, my lord. Thereafter, nothing has happened, my lord. I was
What do you want?
praying for expeditious disposal, my
Of the
lord.
miscellaneous case?
Yes, my lord. And the suit as
You are
well. my
appearing for
lord.
the
For the respondent, Your Lordship.
this application under Article 227 of the matter? একটা সময় ছিল, yes. Yes. Item number 26, yes, madam, please come. Yes.
Your Lordship, I would like to indicate that the delay on our part was bona fide. Your Lordship, we had filed a suit in 2021 in order to ensure that we are not illegally dispossessed of the suit premises which we are using to run our water drinking kiosk, which is only for philanthropic purposes, and we are not deriving any benefit out of it. Your Lordship, after filing the suit, this was filed before 12-judge City Civil Court, who was pleased to grant an order of ad interim injunction to not disturb, demolish the kiosk which the petitioner is enjoying till date. After this, the opposite party filed the eviction suit. In the eviction suit, we filed an Order 7 Rule 11 application. Your Lordship, because the erstwhile advocates, they were of the wrong assumption that since the property is not being used for any commercial or residential purposes, which is why this does not fall under the ambit of West Bengal Premises Tenancy Act. This was admittedly a wrong notion. So correctly, it was rejected by the learned trial court. We went up to we came up to High Court in a civil division application, and even there our contention was rejected. After which we were engaged as the advocates in the matter, Your Lordship.
Yes.
Your Lordship, this civil division order was passed on 17th April 2023. Till then, the client, they were advised that the matter that Order 7 Rule 11 be prosecuted diligently, and just to avoid the multiplicity of proceeding, written statement was not being filed. After 17th April 2023 order, Your Lordship, I filed in June 2023, I filed an application for explaining the delay in filing of my written statement. In addition to that, I also filed an application under Section 7(1) and 7(2) of the West Bengal Premises Tenancy Act.
When did you file that?
June 2023, Your Lordship. It is my application is at
June 2023.
Yes, Your Lordship.
7(1) and 7(2) both.
Yes, Your Lordship. 7(1), 7(2). Along with it, I also filed an application.
Section 5.
Section 5, yes, yes, Lordship. Another application that I had filed was an application to determine the relationship between the petitioner and the parties, because there is some confusion in respect to the ownership even till this date, because the letter of atonement has not been given. Because I had taken the premises on rent from someone else, and the new person who is claiming to be the owner, he has not been able to produce a letter of atonement to me till date. Since I wanted to bring these facts on record, Your Lordship, which is why despite the delay, bona fide delay, Your Lordship, I reiterate that I should be given the chance to file my written statement. I am a private party, and I am only running the kiosk for public philanthropic purposes. If this water drinking kiosk is actually allowed to be demolished, Your Lordship, the public who are actually using the premises, they will suffer, because they are the ones who are using the property on a day-to-day basis, Your Lordship. I have nothing to gain from this property, as I had indicated earlier. I only have created this kiosk in the loving memory of my grandfather, and I would just plead before Your Lordship to allow me to file my written statement before the learned trial court. Your Lordship, the learned trial court proceeding is going on. Witness action is on at this point, I have been told by my advocate on record. And interim
witness action is going on.
Yes, Your Lordship.
Whose witness is going on?
Your Lordship, just if I may. So cross-examination is going on.
Cross-examination of plaintiff's witness.
I'll have to take instructions, Your Lordship, in this.
Yes. Yes, Mr. Ghosh, you are appearing.
Yes.
Yes.
My Lord, mercy petitions. I understand, and it's not something that I'm utilizing for my own self.
Can that be a ground, Mr. Ghosh?
I know, in law there is no ground, I understand, my Lord, but I can only say, my Lord, if we had tried to use our extend our courtesies and good offices, I leave it upon you. If some amount of permit can be given, at least let me contest it.
Cannot be done, Mr. Ghosh.
In law, I know, my Lord.
I cannot go beyond the
that is, my Lord, with the
In exercise of your lordship's power, your lordship can do a lot of. No. Cannot be done. Cannot be done. Divorce the law, divorce the judgments also.
I understand.
This application 97 Act, nothing. This application under Yes, call the next matter.
6.
All at 2 p.m. now. Yes,
Not before,
next matter.
not before lordship rises, my lord, item number 8.
Yes.
Lord, I could not be present with your lordship, my lord, because lack of some assistance, my lord, some wrong information was passed to your lordship. Your lordship has dismissed the revision application.
What wrong
for
information?
Lord, information with respect to, my lord, that what steps have been taken in the trial court below. Your lordship thought, my lord, that it's lord, it was premature. My lord, few facts are required. My lord, if your
What was
lordship kindly-
premature?
Lord, here it's a the propounder is before your lordship, Lord, in a suit for application for probate, grant of probate. Now, Lord, directions for general citation and special citation was passed. Your lordship was informed.
The service has not been made.
That has been made. It has
That
been
submission
accepted.
was
Yes,
made.
Lord, I take that responsibility, Lord. Not it's a maiden appearance, Lord.
Maiden appearance. That was not told.
Kindly, Lord.
Item number
8.
But I will not allow you to move that up.
She will be moving tomorrow. Keeps it tomorrow. She will.
No, not tomorrow. Today itself. 8 দুটোর সময় ওই দুটো fixed matters এর পর।
Your lordship.
Very.
7 come at 2 p.m.
For 8.
My lord,
Yes,
may I please, your lordship, I am appearing for the petitioner, my lord.
yes.
My lord, I am, we are beneficiaries. We have filed one probate case before the learned court below. That was been filed on May 2024.
You are the
And-
executor,
Yes, joint executor.
joint executor, yes.
My lord, general citation is also been done and formal citation also been done. Service upon the opposite party is also done. And we have submitted that publication and service before the learned court below 10/7/2025. And the next date is fixed
What is the next date fixed?
27/9/2025, my lord. For steps. As it appeared from the e-court service, it's steps.
For taking steps?
Steps.
Taking steps by whom? What is the last
Yeah.
order?
My lord, last order.
For what step? That means service is not
For
complete.
acceptance of service.
Or acceptance of service.
But the problem here is, my lord, general citation is there annexed to this petition. Now, my lord, that has already been published. Special citation I have sent with respect to 4 daughters. My lord, the 4 daughters have received. I have also filed, my lord, whatever the service returns are, I have filed that. Now, my lord, despite that, for steps, my lord, the court is recording.
Then, Mr. Kormukar, we have to take steps there. What can be done? For what steps? Nobody knows whether
There
it's,
is no other steps left. My lord, in a probate proceeding, there are 7 heirs. 2 are executors, 1 has given consent, 4 left. Once your lordship kindly, lord, comes to page 15, page 14.
yes.
It comes to page 14. My
Yes.
father has already died. So, my lord,
No, I appreciate that, but what is the order with regard to service?
Lord, with respect to service, my lord, general citation publication made, your lordship would find that at page, my lord, page number. Look, that's the last annexure. Page number is 22 onwards. And the publication your lordship would find at the last page, my lord.
Last page of this?
Lord, civil division application, or this one. I don't know, my page numbering nahi kar na.
This is the citation.
Yes, general citation published Bikopti, Mokam Barasat District Delegate, Adalat Uttar Chব্বিশ Pargona, Probate 55/2024.
Ranjan Mondol.
Ranjan Mondol. If somebody comes and lodges caveat, course will follow. If not,
Paragraph ঠিক আছে। Great. Yes, next. 2 p.m.
My lord, item number 15 and 21, my lord, I am for the petitioner, my lord. My lord, your lordships kindly.
21. Pass over.
My
Next.
lord, I am for the petitioner, my lord. My lord, I am for the petitioner.
Number 36. None appears for the petitioner. No.
Your lordship, I appeal for the respondent.
My lord, I am for the petitioner.
Yes.
My lord, the brief has unfortunately been misplaced and it seems impossible to trace as the advocate on record presently is on maternity leave. So, my lord, I am, if your lordship kindly grant the leave to
Lordship, I'm
obtain
ready to
the
give a copy
certified
today.
copy.
Give her a copy.
I'll Xerox and give a copy.
My
And also, this is a very short matter. This is the ejectment suit 7172, and it was delayed. Section 5 was there. It was rejected
Yes.
according to Supreme Court judgment.
Yes, please take that copy. I'm passing it over. Come at 4. Yes, call the next matter.
My lord.
Please come at 4.
Lord, for item number 30, I'm led by Mr. Tanmay Mukherjee. Lord, he's engaged in court, in the commercial court. I'm praying for days accommodation, your lordship.
No accommodation, sir. Please start.
Lord, I'm not briefed in this matter, my lord. I'm praying for days accommodation, your lordship.
No, sir. Please start.
Well, I'm not the advocate on record, madam.
Then I'm dismissing it for default. Then I'm dismissing it for default. Don't pray for any adjournment. Since you do not have any authority to, you are not the advocate on record, you do not have any authority to make any submission, sir.
I'm praying for days accommodation, your lordship.
No, you do not have any authority. You said you are not the advocate on record. How can you make submission, sir? Where is the advocate on record? Ask him to come. Pass over. Come at 4 p.m. Ask him to come.
Item number 39.
Petitioner preferred this revisional application against the order rejecting order 18 rule 17 application. A suit for matrimonial suit. Here, my lord, lordship will kindly come to page 57. The application order under order 18 rule 57. 59. I beg it. 59 my application. The lordship once heard this matter, my lord. Lordship was wanted to know whether I have in my chief, whether I have taken this issue of these medical documents which I intended to be part of these proceedings.
Pregnancy report.
Yes. Where is your application under order 18 rule 17?
59. It starts at 59.
Yes.
59 for the application.
Yes.
So the respondent filed an application under 127 application of CRPC before the learned Chief Judicial Magistrate Malda, and respondent has been examined as PW1. Respondent submitted the supplementary examination in chief along with some original medical papers and some original money receipts, out of which one money receipt dated such and such, duly obtained from such and such and marked as exhibit number such and such, and connected and in cross-examination in connection with the aforesaid case, I paid a rupee such and such my urinal test during pregnancy such and such. Your petitioner, the present suit was recalled and petitioner has submitted supplementary examination in chief along with the original copies of the evidence of the respondent. That is evidence of PW1 in connection with the aforesaid case.
Where is your evidence?
Yes, madam, that is.
Where is the plaint?
Plaint is page 13, madam.
You are the defendant?
Yes, madam. The evidence was lacking on the last occasion when
No, plaint has been annexed,
Yes,
page
sir.
14.
Evidence of me was not there in the revisional application in the last occasion when your lordship was kind enough to take up this matter. My lord. Was not with me. I have not annexed it. Your lordship wanted to know whether I have taken this in my evidence or not. But that is not the case. By which my lord learned trial has rejected my claim.
No, what is your, where is your written statement?
Written statement at my lord will find that page. After page, that is that my lord will find. 1 minute. At page 23, it starts from the page 23.
Page 23?
Yes.
Yes, how these are relevant?
Relevant for the purpose of my lord, the crux of the matter is for the adulteration life of my client. Just to prove it is my document which I have produced before in 127 proceeding.
125 which you have produced?
127 for enhancement of maintenance.
Yes.
I have annexed all these documents.
Maybe.
But pasting has been put to me. But in respect of this match suit is concerned, especially there is the report of urinary test. This is a routine test. I have
Not
gone through,
pregnant.
my lord, because of the variance cyst has been taken. That is why the examination took place. My lord. It's a routine test, nothing to do.
Yes.
My lord. And they are trying, the plaintiff is trying to establish the adultery on the ground of this case. No, to establish that normal people cannot go for test, my lord. Being a lady, my lord.
No, where is the case made out in your written objection with regard to that? Show me that. Evidence beyond pleadings cannot be allowed. Show me your case made out in the written objection with regard to that. Nothing.
This 121 proceeding was subsequent.
125 is a different thing altogether. 125, 127 is a different thing. Maybe that the scope of that proceeding is entirely different. Show me your pleadings here. Unless you have made this
about the 125 proceedings. This is 127 proceeding. Enhancement of maintenance.
Maybe, sir, how it is related to this proceeding? That's a different thing. Maintenance, you produce whatever documents you have.
But after filing after this match suit, in a connected proceeding, I have filed these documents. Taking advantage of that document, it is my fault that I could not put it into in my examination in the box when my client was in the
This application.
lawsuits, own person, unreported judgment in particular.
What?
It can be allowed.
Yes, it can be allowed. I'm not saying it cannot be allowed, but only what is relevant and for the purpose of administering justice can be allowed at any stage.
Otherwise, my
Not at this stage. Maybe.
Facts are different, altogether. Kind enough to pass this order. Facts are not identical, absolutely. On a ratio to that extent,
Issue that is.
kind, I will be very but my fault, my lord, I have not put question to that.
This application and
I am for the petitioner, my lord. Mr. Shomi's channel is appearing in this matter, my lord, for the petitioner. He is on his legs in court number 26, my lord.
So please start. Yes.
I am paying for a short passover, my lord.
Passover.
41.
My lord, I beg to appear on behalf of the petitioner. My lord, my application for expeditious disposal of an application filed under section 94. My lord, my suit for specific performance of a development agreement, I take out an application for
Yes, what
injunction.
do you say?
My lord, I don't stand in the way of expeditious, my lord. My application under order 7 rule 11 is pending. Their injunction application they filed, I was on caveat, my lord. They served me, I filed.
All right, I am directing the
Will the 7-11 has to be heard out first on the very next day.
No, my lord, on account of that fact, we have filed the application under section 94, my lord.
Their
My
injunction
lord,
application is pending on 39 1 and 2.
yes, my lord, there is subsequent cause of action.
Sir, if this suit is not maintainable, can an injunction be granted? For the purpose of granting injunction, the court has to go into the maintainability of the suit.
My lord, if there is prima facie
Saying
satisfaction.
anything, which application will be
For a
taken up
single
first?
day, my lord, I have taken a
So I will leave it open to the learned trial judge for.
My lord, let
decision
both
as to-
both the applications be heard together, my lord.
That is up to the, I'm directing the applications to be heard up.
All the applications will be heard.
This application
Understanding.
under
Thereafter, both these executors died. Your lordship, the petitioners before your lordship, being the legal heirs of one of the executors, thereafter filed an application for conversion of the probate proceedings to an application for grant of letters of administration. Thereafter, on 4th of January 2017, the plaintiffs and / petitioners before your lordship took out an application under section 247 of the Indian Succession Act, praying for appointment of an administrator pendente lite regarding the subject premises. Thereafter, 5 years later, on 23rd of November 2022, the opposite party, one of the opposite party, being the original defendant number 1, Ms. Renu Hannatka, she filed a similar application under section 247, praying for appointment of administrator pendente lite. This was adjudicated before the learned court on 3rd of June 2023. An order was passed appointing joint administrator pendente lite, me and Ms. Renu Hannatka. Thereafter, your lordship, Renu Hannatka died. After 8 months, within these 8 months, I was the only person, as per the order dated 3rd June, I was the only person taking care of the property as per the order passed by the learned court. After 8 months, the heirs of Ms. Renu Hannatka approached the court. They file an application under section 151, saying that they claim it for appointment of administrator pendente lite, claiming that because their mother was appointed under such and such order, so they have a right to step into her shoes. Considering these applications is the impugned order before your lordship passed on 27th of November 2024, wherein the learned trial court allowed the application and inducted the applicant as joint
What is the
administrator.
infirmity in this order? What is the wrong in this order?
Infirmity, your lordship, is that multiple things. The conduct of the opposite party has to be taken into consideration. If your lordship kindly takes the first application filed by Renu, her mother.
Yes. No, show me the order appointing both of them as joint administrators.
First, if your lordship kindly takes the application, I'll take your lordship.
Show me that order first, thereafter you can take me to the application.
It's at page 97.
Application.
Yes.
Your lordship will kindly come to page 92. This is her mother's application, initial application under section 247. Starts at 92. Your lordship will kindly
allowed.
This was allowed, but your
The
lordship,
order date is 3rd of June 2023.
will kindly take page 96.
Yes.
Affirmed by one Mr. Deepak Kumar Singh.
Yes.
Your lordship, in my respectful submission, this is the caretaker. At that point of time, Ms. Renu Handhaka.
You have not challenged the order dated 3rd of June 2023.
There's a reason, your lordship. I have not challenged because on the same date, Renu Handhaka died. On the date of 3rd June, the same date the order was passed, Renu died. So there was no occasion for me to challenge the impugned order because I was continuing as the sole administrative pendente lite. Had that not been the case, I would have definitely challenged it.
Yes.
Page 96, your lordship, in my most respectful submission, shows their conduct and their negligence regarding the subject premises because they are fighting litigations on behalf of a caretaker who's staying here. Your lordship will kindly now come to the Rajesh, their application under section 151, which starts at page 102.
This is the impugned application. This
Impugned
was allowed.
application. Yes, your lordship.
Yes.
Your lordship will kindly come to page 104, the prayer portion. If I may place it. It is therefore prayed that your honor may graciously be pleased to appoint Rajesh Handhaka, the defendant number 1C, to be the administrative pendente lite under section 247 and to step into the shoes of defendant number 1, Renu Handhaka, in light of order dated such and such.
Yes.
They are claiming to be appointed as administrator pendente lite on the strength of her mother having the right under the earlier order passed by the trial court. In my most respectful submission, that could not have been done. Now your lordship will kindly come to the impugned order.
Yes.
The last page of the impugned order, your lordship.
Yes.
Second para.
Yes.
The interest of both the parties are involved in the property in question. The bequeathed property include both 44A, Rafi Ahmed Kidwai Road, and 44B. Your lordship, there's a story here. In my most respectful submission, for this entire will does not pertain to 44B at all. They are claiming to be the co-owners by challenging the will in question. And they say that they are owners of 44B. The bequeathed property before your lordship has nothing to do with 44.
What is the bequeathed property?
The 44A. Your lordship, what had happened was earlier, the subject premises.
44B, who is the original owner?
I'll tell your lordships. Earlier, it was just 44 Rafi Ahmed Kidwai Road. There was a compromise decree passed by this honorable court in 1956, wherein it was bifurcated into 44A and 44B. 44A went to my grandfather, 44B went to my grandfather's brother, Mamchand Murarilal. Mamchand thereafter will, whatever has transpired has transpired. The other 44B
will is with regard to 44A.
44A, your lordship. That is my respectful submission, and that has been admitted by them in their applications as well. I can show your lordships. 44B is regarding 44B went to my grandfather's brother Murarilal Agarwal. He died. He was
according to you, they do not have any right in 44B.
Yes, your lordship. So the trial court proceeded on the basis that they have mutual interest in the property because the bequeathed property pertains to 44A and 44B. In my respectful submission, it pertains just to 44A, which was allotted specifically.
Only the affidavit of assets in the probate application.
That subject to correction.
That
I
is
don't
not
think
here.
is annexed, your
All
lordship.
right. Show me the will. Will is annexed. No.
Will is also not annexed, your lordship.
Anything to show that only 44A is the subject matter of that probate proceeding?
They have admitted, your lordship.
You have admitted.
All right.
They have admitted. It is an
Yes.
admitted position.
That is a mistake. We filed an application for correction of that mistake also.
So you say only 44A.
44.
All right.
So as far as this is an admitted position that the bequeathed property pertains to just 44A of Rafi Ahmed Kidwai Road, my respectful submission is, being the heirs of the surviving executor, only we had the right to file the application and be granted as administrator pendente lite over the subject premises. one last point, Your Lordship. Why they could not be appointed as joint administrator is because there are adversarial litigations pending between me and them. We are trying to be an.
You also be removed. Let a third party be appointed.
But Your Lordship, there has been
Because there are adversarial litigations between you and him. So I think both of you should be removed, the third party should be appointed.
Your Lordship will kindly not take me amiss. There have been no allegations.
It's better since both of you are fighting, let a third party be appointed. I think that's
Your Lordship, from day one, I have been looking after the entire premises, collecting rent, paying taxes.
They are making allegations against you. You are making allegations against them. All these will end. I am appointing a third party.
I'll have to take instructions on that.
Your Lordship, take instructions. That will be.
Your Lordship will kindly keep it on the next date. Mr. Banerjee will.
Mr. Banerjee.
The intention of the learned court below was all the time, Lordship will find at page number 96, to appoint a joint administrator.
What is 96?
The earlier order passed.
98.
Page 98, my lord.
Yes.
Lordship, kindly see the ordering portion is at page 100.
Yes.
Vinti Khemani, plaintiff number 1 and defendant number 1, Renu Hannat.
You are defendant number 1.
Defendant number 1 originally passed away. I am
the heir of defendant number 1.
Yes. Now, they were appointed as joint administrators to open a joint bank account, which shall be operated jointly. Tenants to be taken, rent to be taken and everything to be maintained by them jointly. After her death, after the death of my predecessor.
When she died?
On the same date, Your Lordship, 3rd of June.
On the date on which order was passed. They took everything in their hands. Now they have smelled blood, maybe. Now they are wanting that they should only continue, and the legal heir of this lady who has already died, her legal heir cannot be brought as an administrator so that it can be taken out in a smooth way. But we want things to be carried out smoothly. But they will file report.
You are not. You also do not want to be carried out smoothly. He says that you are creating problem.
But then a third party be appointed. We have no objection.
Your Lordship will kindly take some things into consideration. I had filed my application in the year 2017. Please.
But in that event, what will happen is the funds would be drained out of the executor and everything account.
Because both of you are fighting, let it be drained.
We are not fighting. Let anybody from us, from our chain, be appointed along with them. I am not standing in the way of him being an administrator there, but there should be somebody else.
Yes.
My learned senior friend says that we are not fighting, so kindly let me continue as I have been continuing since the year 2014. Your Lordship will take certain things. So the best of the subject premises was definitely not their concern. Once the Renu Harnatka died, they approached the court after 8 months. Again, the best of the subject premises, the interests were not
the total rental income of that property.
I will have to take instructions, Your Lordship.
60,000 per month. I am told 80,000 per month.
And under their own application for Section 27, that no case has been made out that I have been mismanaging the property. I have been running the property.
Yes, you run. I'm not removing you. This application under Article 227 of the Constitution of India is at the instance of you are the executor.
I'm the heirs of the executor. Legal heirs of the executor, Your Lordship.
Legal heirs of the executors.
Executor. One of the executor is my father, Mr. Krishan Kumar Agarwal.
All are defendants opposite parties. Who are the petitioners in the Costa?
No, Your Lordship will find it. There are.
Oh, sorry. This application under Article 227 of the Constitution of India is at the instance of the plaintiffs and is directed against an order being number 161 dated November 27, 2024, passed by the Learned Additional District Judge 10th Court at Alipur in original suit number 71 of 1997. So by the order impugned, the application of the defendant number 1C for being appointed as the joint administrator pendentility along with the plaintiff number 1 stood allowed. First of the learned advocate appearing for the petitioner submits that the learned trial judge allowed the defendant number 1C to be appointed as a joint administrator pendentity only on the ground that his predecessor in interest was appointed as a joint administrator pendentity along with the plaintiff number 1 by virtue of an earlier order. He further submits that the learned trial judge proceeded on the basis that the subject matter of the probate probate suit is the subject matter of the probate suit are two immovable properties bearing number 44A Rafi Ahmed Kidwai Road and 44B Rafi Ahmed Kidwai Road, though the premises being number 44 Rafi Ahmed Kidwai Road does not form the subject matter of the probate suit. First of all, he further submits that the opposite parties he further submits that the defendant number 1C is the opposite party number 1C.
Yes.
Which
Mr. Rajesh Rannatka.
Which opposite party number?
3, before your lordship.
Opposite party number 3.
Yes.
That the opposite party number 3 herein, who is the defendant number 1C, will create unnecessarily complications in the administration of the estate while acting as a joint administrator pendentity. First, a paragraph, Mr. Banerjee, learned advocate appearing for the
Opposite party numbers 1 to 4.
Appearing for the opposite party numbers 1 to 4 submits that does
while dictating the order in the front portion, Lordship has said premises number 44. That should be 44B.
44B একবার দেখেন তো,
একদম
দুটো আছে
প্রথম দিকে।
44A আর 44B 44B
এক
টা
জায়গায়-
does not form subject matter of the
At one place only, Lordship has said 44B. 44 instead of 44B.
যেগুলো শুধু 44 বলেছি 44.
Madam, great.
Yes, call the next matter.
Obliged.
43.
My lord, in item number 43, my lord, I am appearing on behalf of the petitioner. My lord, my lord, in this petition, my lord, we have challenged, my lord, the order passed by Motor Accident Claim Tribunal, my lord. My lord,
Yes.
my lord, we have preferred this, my lord, petition, my lord, stating that, my lord, there is a limitation period, my lord, which has been introduced in the year 2022, my lord, which says that, my lord, a claim petition cannot be filed beyond the period of 6 months. My lord, on an earlier occasion, my lord was dealing, my lord.
No, show me that order. Where is that order?
My lord, order is at, my lord, last page, my lord.
No, I have passed an order on that.
No,
I
my
have
lord, my lord,
admitted.
that was in respect to section 164, my lord,
Yes.
which, my lord, today, my lord, I am not carrying that order, my lord, but
All right, so this is on
166, my lord. My lord, on that occasion, my lord has held that in under 164 there is no limitation, but my lord, in terms of 166.
This is 166.
Yes, my lord, this is 166, my lord, and in terms of 166 subclause 3, my lord, specifically, my lord, amendment, my lord, of 1st April, my lord, 2022, my lord. This,
Yes,
my lord,
Mr. Singh, you are for the petitioner.
Lordship, now let him not proceed.
Yes.
kindly, my lord, once.
Where is that judgment?
That judgment, my lord,
My
today,
lord, judgment is pending before Supreme Court now. The main issue is pending before Supreme Court. On the last date, your lordship, my lord, we were under section 164. So your lordship said in 164, my lord, your lordship gave us a chance to come back. But in
Yes.
166, it is very clear. But still, it is pending before Supreme Court.
This is after the amendment.
yes, my lord, the date of
This
accident.
application is after the
Yes,
amendment.
my lord, date of accident was.
And what happened? Section 5 allowed.
Yes, my lord, section 5 was allowed.
So according to you, section 5 cannot be applicable.
So, my lord, the statute is very clear, my lord, that it is specific bar is there, legislation, it is wisdom has thought so, that no further time should be granted. But, my lord, be that as it may, Supreme Court has to decide it ultimately, it is, my lord, keeping the maintained session, my lord. Because, my lord, throughout the country, my lord, a number of cases are being filed, my lord, all those are culminating in Supreme Court.
By the order impugned. Mr. Singh, get it disposed of because this is an issue beneficial. If these matters are kept pending,
Milord,
How
Supreme
long-
Court, Milord, throughout the country, Milord, at least 10, around 10 applications, Milord, they all have culminated in one particular matter. Milord, Supreme Court, Milord, I do not know when their lordships would be at their pleasure to decide. But Milord, their lordship must be worried, Milord, because throughout the country it is happening. Everywhere it is happening, Milord.
Yes.
Milord, I have got 40% in my favor. I should be very candid, 60%
Compensation
against.
on these.
Yes, it should be. It should be. But Milord, the issue has to be decided, Milord.
Thank you.
Extremely grateful, Your Lordship.
Next.
Number 44.
Your Lordship, item number 44, and for the petitioner, Your Lordship, during the pendency of the revisional application, the suit has been dismissed for default on 30th of July 2025.
The learned advocate. None appears for the petitioner at the
Your Lordship, item number 46. This is my application, Your Lordship. I filed one application before the appellate court under section 202 Premises Tenancy Act. Now that application has been decided, Your Lordship. It has been disposed of. So this revision application has become infructuous.
the learned advocate appearing for the petitioner. Yes.
Lordship, this is an order, civil revision from a state commission's order dismissing my original application.
Appeal lies. National
Lordship,
Commission.
Your Lordship, let me satisfy Your Lordship. This order, I have taken 2 points that this order has been passed by a single judge. There was a judgment passed by the Rajasthan High Court. Single bench had passed an order wherein the single bench.
Where is the Supreme Court judgment, madam?
Your Lordship, Supreme Court judgment I have annexed,
Give
which
the
is
Supreme
which
Court
is at page 30, Your Lordship. The Rajasthan High Court order went in appeal in SLP. The SLP order is at page 30.
30.
30. Operative part is 31. It doesn't discuss, so I have brought the Rajasthan High Court order, which discusses the entire facts.
Oh, from this SLP was.
Your Lordship.
Can you not take this point in the appeal?
Your Lordship, this was also decided in a writ petition under 226, 227. Going before Delhi becomes and this matter has been dismissed on ground of dismiss for default. Your Lordship, what had happened, the conducting advocate's grandfather had died on the date when the matter was fixed.
Show me the impugned order.
Your Lordship, the impugned order is at page 28. Your Lordship may be pleased to see page 28 and 29.
No, which is the order under challenge?
Page 28, Annexure C.
No, order dated?
Order dated 26 July 2024. Complainant was found absent on repeated calls. Learned counsel appearing for the opposite parties is present. Fix the date for filing. Today is fixed for filing of show cause by the complainant. That is necessary. Order will follow. Show cause is forthcoming from the end of the complainant. In the circumstances, the performance of the complainant inspires me to hold the complaint. I am not willing to proceed further with the present complaint. Ordered that the present complaint being and the same is dismissed for non-compliance with the Commission's order but considering the circumstances without any order as to cost, Your Lordship, on the right-hand side said Satyanand Trivedi, member. It's not even a judicial member. It's just a member. The Rajasthan High Court had dealt with the judgment that whether a member can go at all sign an order and pass an order in single judge. Your Lordship, page 29 was the order. Before that, 22nd May 2024, none appears on behalf of the complainant on call, learned appearing.
Have a copy of the Consumer Protection
Your
Act.
Lordship, I have it. Look at that.
The issue that arises for it will come in the list in November after some matters are disposed of in September.
Your Lordship.
Lordship, I make appear on this, Lordship. This is a suit for partition by meets and bounds. There is an order of status quo.
What is the order under challenge?
Lordship, I filed one application under 151 to reinsert petition number 2 into the suit property, Lordship. Suit property. Petition number 2 into the suit property, Lordship. Actually, after the order of injunction in the nature of status quo, in the December 2023, petitioner went to her matrimonial house at Tripura.
What is the application dated 2nd of April 2024? You are challenging the order dated 7th of November 2024.
7th of November 2024.
Yes. So by that order, an application dated 2nd of April was rejected. What is that application?
that application was for police help to reinsert plaintiff petition number 2 into the suit property, Lordship.
How can it be done, sir?
Lordship, kindly come. After
Ad interim order of injunction
yes,
cannot
there
be
is,
done.
Lordship,
Sir,
see-
cannot be done.
she is
What is the injunction application has been disposed of?
Lordship,
Has been disposed of. When it was disposed of?
after filing this
So apply there after this. Ad interim order of injunction cannot be implemented, sir, with police help.
kindly consider my Lordship. After ad interim order of injunction, the father-in-law of the petition number 2 died. She went to Tripura. She actually is residing in her paternal house, as she is government employee and residing in her paternal house. When she returned, the defendant opposite party refused her to enter into the house. All the belongings, all the
Show me the order passed on the injunction application. That will be not here because you have said that after this order was passed. Where is that?
I have annexed the ad interim in
Not the ad interim, the temporary injunction. What happened?
in temporary injunction, Lordship, on 19/12/2024, the ad interim order was confirmed, Lordship.
Yes.
Status quo.
Yes.
Status quo is there.
Show me that order.
Lordship,
Show me that order.
Lordship, kindly fix it at 4. I am coming with the order, Lordship, with the server copy.
Sir, ad interim order with police help, it cannot be passed. Since you are saying that temporary injunction application has been disposed of, I give you liberty to file an appropriate application for police help. Ad interim order, police help, by police help, it cannot be done.
Lordship, I am staying outside my house.
Mandatory injunction you have to pay for. Have you amended your plaint? You are the plaintiff.
Lordship.
So now, according to you, in violation of an order of injunction, you have been ousted.
Lordship.
So now you are not in possession.
No, Lordship.
So now your remedy lies in restoration of possession or mandatory injunction. Apply for that. You have to amend. You have to amend the plaint then, or I can give you liberty to file an application for police help of the temporary injunction. Since you are now out of possession, whether on that particular day you are in possession or not, that has to be decided. It cannot be decided in this way. Evidence is to be taken, sir. Mandatory injunction.
Lordship, all my belongings are in my paternal house. Lordship,
For that, evidence is to be laid. You have to prove that fact by evidence. So how can it be by way of an interlocutory application? Do that by way of a suit.
subsequently, I have filed one application under Order 13 and Rule 7, Lordship, for local inspection.
So do that. So I'm giving you liberty to take appropriate steps in the suit. Awesome. This application.
Decree holder is the respondent and petitioner before your
Decree
lordship.
holder is the respondent.
Petitioner before your lordship.
Respondent in the appeal.
In the appeal, my lord.
Petitioner. Yes. What do you want? What is the order under challenge?
Suit for eviction, and it was decreed in favor of the landlord and petitioner, and thereafter they filed a title appeal before the learned court below, where they also filed an application for stay of all further proceedings. The
occupation charges have been directed.
Yes, my lord, but it is too low. 12.
I'm expediting 2024. I'm expediting the appeal. Otherwise, your appeal will be getting delayed.
And one the date of the order it was passed there not from the date of the filing of the application or
Sir,
filing
it will get pending then here. I'm expediting. What is the stage of the appeal?
It was filed. Just the application has been moved.
No. It's September. It was for awaiting the lower court records. I'm directing the. If you want, I can. But it will be getting
It is
delayed here.
near the Baliganj railway station, my lord. And they also had the tenant purchased the property and shifted there, putting lock and key in the suit property.
That is a different.
And somehow used commercially this property. And for that reason, I am.
What is the extent of the property?
The extent of the property in the title should, my lord, kindly come to page 14. It was
made of bamboo structure.
It was at that time. Thereafter, they modified the property, and for that reason,
So your suit property is this application under Article 220. Yes.
Lord, I am for the petitioner.
Yes.
Well, there is no scope for an interim order. I am the plaintiff, and my application
There is
under
no
order.
scope to entertain also.
No, my lord, that, my lord, perhaps might be.
That is there.
Kindly, my lord, consider. Yes.
Yes.
My lord, my application under Order 12, Rule 6, my lord, has been rejected.
What is the suit for?
My lord, suit is for recovery of money. It's a money suit. 20 lakh rupees given admittedly to the defendants. Accepted that 20 lakhs have been repaid. 20 lakhs has been paid by the plaintiffs to the defendants. The defendants also, my lord, admit to have repaid 8.5 lakhs, which is in my pleading in the suit. 8.5 lakhs I have received. And my lord, there is an acknowledgement, my lord, which has been missed out inadvertently in this application. It should have been an annexure It's been referred to, my lord, in the draft. But I'd like to bring that acknowledgement on record, my lord, by way of a supplementary affidavit. But, my lord, may I just say this? My lord, their response is, my lord, they're even admitting, my lord, to the acknowledgement. That it's their acknowledgement.
Show me.
They are just saying that after the acknowledgement, in cash, everything is settled. My lord,
No, so that's admission is not there.
my lord, just,
So it has to be decided.
my lord, kindly consider. My
So
lord,
my first observation is right.
my lord,
This application under Article
my lord,
227.
kindly consider. Judgment of the Supreme Court, my lord, stipulating guidelines of how these alleged cash transactions, my lord, are to be dealt with. My lord, kindly see the defendants deny and dispute the statement and so in paragraph so and so.
Defendants were genuine in their endeavor and such issued the statement of confirmation and shortly thereafter made payment of the same in cash. As such, there is nothing due and payable
No, my lord, who?
towards the plaintiffs and are not eligible to any amount as claimed.
So, my lord, where is
They have
the?
denied, no admission.
My lord, how will this be proven, my lord? Is there any chance of this even, my lord, succeeding in trial?
That's a matter of trial.
Lord.
So you have to face the trial to see how they prove.
My lord, may I just make one last attempt? My lord, just kindly consider a situation. My lord, acknowledgement, my lord, admission, my lord, judgment upon admission, my lord, it can be any kind of admission. It can be an admission by way of a letter, by way of, my lord, a balance confirmation.
This is not an unqualified admission.
My lord,
This is
so
not an
in a-
unequivocal admission for the purpose of Order 12 Rule 6. Admissions are to be clear, unequivocal.
Your lordship,
It's not a clear and unequivocal admission.
I understand what is coming from lordship. My lord, my only, my lord, concern is that, my lord, if this is so,
What did the trial court say? Let me see.
trial court has just made that finding that there is no unequivocal admission.
Rightly. This application under Article 220.
Kindly just, my lord, one last. Kindly consider, my lord, if this is, my lord, if the law is interpreted to be this, then in every case, my lord, just by, my lord, one line in the pleading that we have paid in cash will undo any admission that may have
This
been made.
application under Article 227 of the Constitution of Yes.
My application is rather voluminous, but the issue is very simple. In one line, I can say, I file a suit. It was more of a preemptive suit to restrain a party from making a claim against me. During the suit, certain subsequent facts are transpired. I intended to incorporate them by way of an Order 6 Rule 17 application when my application for injunction was being heard. So learned, I took out a very innocuous application saying that do not take up the injunction application because these subsequent facts have to be brought on record. The learned judge has rejected my application saying that no, I will hear the injunction because it is being heard from a prior date and only after disposal of the injunction I will consider the application in Order 6 Rule 17.
So it has been postponed, not rejected.
Postponed, but the amendments have to be incorporated. My entire volume
That has not been dismissed.
Not dismissed, but I take the lordship.
What happened to the injunction application?
Still pending, but it cannot proceed. The entire volume is on the subsequent facts. I tell you, lordship, what had happened. The other party is in, I believe, they're in Nagaland. Imphal, yes, Imphal. Manipur, sorry. They're in Manipur. So subsequently, we discovered that he has filed a suit against me, which has been decreed. Against which I have taken out an application seeking vacating of the ex parte order. All those facts had to be brought on record. The entire volume, my application under Order 6 Rule 17, lordship starts at page 51 and it runs through the entire breadth of the brief.
No, why it has been said that it is technically defect?
No, the application I had taken out a very one-page application saying that the learned judge had indicated her mind on a previous date that I will take up your injunction, will not take up the Order 6 Rule 17 application. So by abundant caution, we took out a 151 application requesting the learned judge to take up the application under Order 6 Rule 17 prior to disposing of the application under Order 39 Rule 1 and 2.
What is your application under Order 6 Rule 17?
This all subsequent. It is a page 51 of my.
What is your suit for?
Suit for declaration and injunction. Declaration.
What is the declaration sought for?
Declaration, I'll tell you, lordship, what had happened. I had supplied red sandalwood to the defendants herein. So there were certain transactions which transpire subsequently to which he said he will set off a particular amount. Then when it transpired that he was not going to do that, I filed the suit. But what happened in the meantime was my suit unfortunately got dismissed for default. In the meantime, he filed a suit, the defendants filed a suit before the courts at Manipur. They obtained an ex parte order, a decree against me. Upon becoming aware of that, I have taken an application seeking recalling of the ex parte decree.
So you have filed a suit for declaration that the forfeiture by the defendant?
Yes.
Forfeiture of certain amounts?
Yes.
On the wrongful termination of the contract? What is the amendment? Show me.
Kindly comes at page 51 is my application.
For amendment?
Yes. The schedule is at page 55. I'm not hit by the proviso because trial has not commenced. It's still in at an interlocutory stage. And kindly see after paragraph 17 of the plaint, these are all subsequent facts. Subsequent to the filing of the suit.
So application for injunction filed by you?
Yes, 2011.
So injunction application has to be dismissed. If you cannot succeed on the original plaint, it requires an amendment. So injunction on the original cause of action does not suffice.
That is exactly what I was on, your lord.
Draw the injunction application, end of the matter. Your amendment can be heard out. That's the easiest way.
That's the easiest way, sir. I did advise my client that even on subsequent facts, or application 151 is also.
If you cannot succeed on the original plaint, it requires an amendment. Injunction also you cannot get on that. Withdraw that injunction application and move the application for amendment. That's the easiest way.
Kindly directs the court to hear out my application.
Withdraw the injunction application, I will direct that.
I will give an undertaking to withdraw it.
That application for withdrawal, I will direct the court below to consider.
I'm grateful.
After some argument, the learned advocate appealing for the petition
Item number 52.
None appears for the petition at the
Item number 53.
53 my application. The petitioner is the wife preferred an application for under section 36 of the Special Marriage Act and learned court lordship directed to pay lordship 7,000 rupees per month and lordship 10,000 as litigation cost. Against that order, lordship, I has preferred this application.
What is the income of the husband?
Lordship, he is a YouTuber and earns a lot. I have annexed you, lordship, kindly come. Lordship, kindly come. He has got a car, he has a two-wheeler. Your lordship, kindly come to page 38 from NIT. Lordship, 39, your lordship, kindly come from 39. This is the bank statement, lordship. Money transfer of page 40, 8 lakhs, lordship. Your lordship, kindly see that. Thereafter, next page, 4,51,000 from YouTube, Google. And thereafter, 6,13,000 and odd lordship. That is from also YouTube, Google Asia. And 4,77,000. Another 8 lakhs lordship. All I have annexed. 9,38,000.
By the order impugned.
Pending hearing.
My lord, I appear for the plaintiff petitioner, my lord. Suit of 2011, eviction suit. Thereafter, the defendant had filed 7-2 application on 4th of July 2011. And the 7-2 hearing is still pending, my lord, for the 14 years. After I have filed this application in December 2024, after that, my lord, 9th of January 25, 7-2 hearing took place. Order was reserved, my lord. 2 dates have gone by. 21st March 2025.
Order on
and
section 5.
With section 5, 7-2 with section 5. 14th May was the last date, my lord.
Under Article 227 of the Constitution.
Five.
55, Lordship, I am for the petitioner, Lordship. Lordship, learned advocate appearing in this matter, Lordship, engaging in another courtroom, Lordship. Kindly praying for not today, Lordship.
That is not the ground, sir. Please proceed.
Lordship, let this matter, Lordship, short pass over, Lordship, kindly.
What is the order you are challenging? What is the order you are challenging?
Lordship, I don't have gone through the brief, Lordship. Lordship,
This application under Article 227 of the next.
6.
No accommodation, madam, please start.
Your is appearing due to some difficulty. She could not come to court, madam. The brief is also with her. So I have no knowledge, madam. Only a day's accommodation. And if it's tomorrow.
Or days it will not come, madam, please then don't mention for upgradation thereafter.
Yes, your lordship.
Please don't mention for upgradation thereafter.
But as per instruction, I am praying for accommodation. Otherwise, there will be some difficulty, madam.
On the prayer of the learned advocate for the petition.
That is number 57.
And appears for the petition at the time of
58.
I'm for the petitioner.
yes.
Plaintiff petitioner amendment application is disallowed.
Disallowed.
Kindly come to page.
How could it be disallowed?
Kindly come to page. Shoot, my lord. They are 17. Page 19. Page 19. The plaintiff stated that the Co-1, Co-2, Co-2, Co-3 scheduled property, the alleged gift deed, but the same was not incorporated in the schedule of the land, schedule of the plaintiff.
Show me your plaint.
Plaint page 16, para 7, para 12, and prayer.
Due to mistake, my lord, same was not reflected in the schedule.
Where is the amendment application?
Page 20, my lord.
Page 12.
No, man, page 28. Page 28. Man, page 20 of the plain schedule.
No, this is the amended plaint. No.
No. In the schedule plain 20, page 20, that core 1, core 2 not mentioned due to inadvertent mistake.
The particulars of the deeds were not mentioned.
Yes, madam.
By the order impugned, the Stands allowed বলেছি তো? No. Yes,
This matter, I am appearing for the bank, but we have not been served a copy.
none appears for the petitioner at the time of call, no act.
Item number 60.
None appears for the petitioner at the time of call, no accommodation.
One.
61, my lord, I am for the petition.
Yes.
But a suit for declaration of tenancy right, my lord, I am the plaintiff. Now, my lord, the defendant, my lord, took a stand, my lord, that out of 111 square feet, 85 square feet has already been, my lord, delivered, my lord, tenancy was surrendered to them, and my lord, vacant position was delivered. My lord, to establish that, my lord, kindly sees the defendant took this amendment, and my lord, immediately, my lord, filed an order 39 rule 7. My lord, kindly, my lord, comes to my lord, page number 28 onwards, 28. Kindly sees, my lord, the schedule. All the schedule are with, my lord, related to the extent of position. How far I am in position, how far the defendants are in position. My lord, no documents, my lord, to show, my lord, that already, my lord, vacant position was delivered to them with respect to, my lord, 85 square feet. On page number 26, my lord, the application starts. Averment, my lord, they made it in WS, and my lord,
What is the averment that this was surrendered? Where is that?
yes, my lord. From the written statement, I'll show. My lord, kindly, my lord, comes to page 18. Page 18, the last paragraph. And my lord, same averment has been quoted in the application as well. Page 18, the last paragraph, which starts from, my lord, on 19/5/2021. May I read, my lord, for your lordship? My lord, kindly, my lord, comes to page number 27, paragraph number 3. The same averment has been quoted, and the schedule is in page number 28.
It primarily appears to this. Contested application after 12 weeks.
Item number 62.
I am for the opposite party.
Yes, what happened? Suit disposed of?
No, your lordship, it is still pending for the lordship.
Yes.
I think it was dismissed.
What is
on
the order,
earlier
your lordship?
occasion.
Where is Pune?
Kindly come to the lordship page number. Dismissed on earlier occasion. I think it was dismissed on earlier occasion.
Dismissed?
There
No
was
order.
there is an application CAN 1 for seeking restoration.
When it was dismissed, there is no order sheet here.
This is your application.
Lordship not served, Lordship.
You have filed.
No.
Yes, what is the impugned order? No, 62. Which order you are challenging, sir?
Lordship, kindly, we are
15th of
agreed.
January.
So we are agreed with the Lordship the long pending of the Lordship the suit before the Lordship the concerned trial.
Expeditious hearing.
I'm praying Lordship for expeditious Lordship disposal of the trial the suit pending.
My lord,
You don't want that.
suit for declaration, injunction, recovery of possession filed by my client as a plaintiff.
Yes, so he wants expeditious hearing.
His prayer is not that. He came up against the order passed in title appeal where the learned first appellate court.
Title appeal?
Yes. Miss appeal. Where the learned first appellate court.
No, this order is under challenges of the in suit. 18th of January 2024.
Prayer is appearing in Lordship page number 7 of the writ petition.
So Mukherjee, what is the cost title? Same matter. CO 4202.
No, 4181.
No, this is 4202.
কত নম্বর বলছিস?
Yes, Mr. Mukherjee. This happens when you have too many matters. It's very difficult to keep track.
Matter is also different, Your Lordship.
Yes.
Shown there from the Lordship.
Yes, 18th of January.
So last order passed the Lordship in 18th of January 2024, Your Lordship.
Let me check up my.
This was the Lordship order passed by the Lordship learned trial court concern. So now, Your Lordship, the petitioner, Your Lordship, is the respondent herein in the title suit, being Your Lordship number 76 of 2024, where Your Lordship the petitioner is intended to construct his building, Your Lordship, the residential house over a property. All of a sudden, Your Lordship, the respondent filed a title suit before the concerned court. Inter alia, Your Lordship,
Injunction has been disposed of or pending.
Injunction application. Last occasion in Lordship on 18th of January 2024.
What happened after that?
The Lordship, after that, Your Lordship, there is no as such order passed by the Lordship trial court.
So injunction is pending. This
so
application under Article 227 of the Constitution. Yes, Mr. Chokku, you are appearing. None appears for the petition at the time of call. No accommodation.
My lord, I am opposite party in proceeding for preemption under section 8. My lord, sale has been completed. The registration has been completed in the year 2010. Thereafter, I mutated my name. I constructed building, and in 2021, preemption case has been filed. I filed application for challenging the maintainability, and that has not been allowed, and for that I have come, my lord. But I am, my lord, fortified with the judgment of Honorable Justice Jyotirmay Bhattacharya, my lord, in the matter of, my lord, Nurul Islam versus Estarun Bibi. That will be there. It will be governed.
Non-notified co-sharer 1 year limitation.
Yes, 1 year. So
That judgment.
yes.
Yes.
So, my lord, let the matter notice be issued by, my lord. I am praying for.
Show me the preemption application.
Preemption application, my lord. Kindly see page 18. He has admitted. Page 18, paragraph 12. That from the certified copy of the impugned deed of sale, it appears that the OP number 2 to 6 executed the impugned deed of sale on 16/7/2010. It is the admission of the petitioner.
And when this application was filed?
My lord, application in the year 2021. My lord, kindly see the page number. Page number, my lord, 12. My lord, this is, my lord, 8 of 2021.
By the order impugned, the application filed by the petition. None appears, dismissed for default. Next. For the next matter. Item number 66. Same order dismissed for default. Next. Item number 66. Same order dismissed for default. Next.
7 बोला है.
6 same order dismissed for default. Next. Item number 67.
67 lordship I am appearing.
Yes.
67 টা আমি দিয়ে দিলাম আগে দেখুন. Actually, I'm for the petition 967.
Yes.
Actually, I'm for the husband petitioner, my lord, husband in the matrimonial suit. But just a while ago, I received an instruction that there is a talks of settlement going on between the parties, and the next date it's fixed on 13th of this month itself. Then it means that the parties may have.
What is the impugned order? Talks of
Impugned-
settlement
Impugned order is
long it did not happen. Let me see what is the impugned order.
impugned order is of amount maintenance has been granted of 8,000 rupees.
You are the husband.
I'm the husband.
Yes. Are you paying that?
Actually, my instruction is that yes.
You are paying.
And because there was a settlement and one-time settlement is going on, so I need to take some instructions on that. And the next date for
8,000 maintenance you are challenging, sir.
But the admitted income is that 9,000 rupees.
Whose admitted income?
The income of the husband is 9,000 rupees, and thereafter.
Show me your affidavit of assets and liabilities which you have filed. What is the expenses which you have stated there?
Worship, it's at page number. Uh, 47 onwards. It begins from page number 46. Relevant portion is 47 onwards.
So your monthly expenses is 7,000, 2,000 is doctor's expenses, total is 12,600, and your income is 9,000, sir. Is it believable?
Income from the it's at page number 450.
So 47 expenses.
It says income from the monthly income from employer NK Gosai printer.
Yes.
It's 9,966. And
so how are you bearing the expenses of 12,600 per month?
In the next page there is something more, Lordship. It's at page number 52.
Yes.
52, it says that there is a gift shop of joint ownership of mother and the son, and it's 3,400 per month.
Yes. Any documents to show that shop, from that shop you are having only 3,500, 400 income?
Because it's a business of the father. That has been stated in the affidavit. Business of the father.
You are in absolute control of that business.
Because father is now Lordship.
Any documents to show? What is the? Have you prepared the accounts of that?
So that has not been disclosed here.
Yes. So it's unbelievable, sir.
Here, Lordship, it's
13,000 income, 12,600 expenses.
And but
8,000, sir. It's reasonable.
Sure, but kindly do not pass the order today itself, because the kindly keeps it on any day after 13th. Then Lordship passes an order. Kindly keeps it on any day after 13th, because there is a one-time settlement talks are going on.
Going on.
Lordship,
Learned advocate appearing for the petition.
kindly keeps it any day after 13th.
Learned Yes.
I'm opposed.
My lord, I am for the petitioner. My lord, in this revisional application, petitioner challenging the order dated 6 September 2024, passed by the learned civil judge, Junior Division, 4th Court, Alipur, in ejectment suit number 226 of 2019, and
What is
thereby
the impugned order? What is the nature of the impugned order?
the learned trial judge rejecting the prayer of the petitioner under section 7 subsection 1 and 2 of the West Bengal Premises Tenancy Act 1997 without granting to condonation of delay.
What is the period of delay? When did you enter appearance? When this application was filed?
Fine.
Five months.
Fine.
Yes, sir. What do you say?
But it's well settled now. It's well settled now. There are two judgments. Milord, one of the Supreme Court judgment has been relied upon in the order sought to be impugned. And Milord, following that, Milord, there is Milord, your Lordship is quite aware of Milord Calcutta Gujarati, Milord.
This application under Article 226
Party number 38.
My lord, I am for the petitioner, my lord.
Yes.
My lord, due to death of one of the relative of Mr. Tanmay Mukherjee, he could not come to the court today. My lord, make it not today, my lord. I am sorry.
What is this matter?
Matter is very simple. The suit filed for eviction.
Yes.
My lord, decree passed.
Yes.
Decree put in
Decree
execution.
passed.
Decree passed.
Yes.
Decree,
Thereafter,
decree put in execution.
decree put into execution.
Execution.
Yes.
And then, my lord, a third party makes an application under order 21. Rule 99, 100, 100. My lord,
Yes.
find it, page 37.
Page 37. Yes.
This is the application.
Yes.
Now, this third party is, my lord, will see the petitioner, Sri Abhishek Kejriwal.
Yes.
Now, my lord will see the prayer, just a prayer. At page 59. Page 59. My. Prayer, my lord.
Yes.
That the petitioner association, KMRA.
Impugned order.
Now, this proceeding is going on. Section 5 has been filed with order 21. Section 5 has been filed, and the witness action is going on.
No, section 5 for what?
For condoning the delay of the application under section 21. Under order 21 rule. This application. Section 5, my lord will see the application.
No, which order is under challenge?
The proceeding, the court is proceeding. My execution proceeding has been.
No, execution
But
will
my lord,
proceed. What is the
this
order under
application
challenge?
under order 21 itself is misconceived, my lord.
It has been fixed for evidence. What happened thereafter?
Thereafter, they are taking time, my lord. PW3, my lord will see. My lord will see the order sheet, which I have an.
You want expeditious hearing of this?
No, I am saying this application under order 21 is not maintainable.
Have you filed any application raising the issue of maintainability? Where is that?
Before the court below.
Yes.
That I have not. I have come here. My lord, see the prayer. My lord, see who has made the application. What is the prayer, my lord?
You file an
This prayer can be
application.
allowed.
You file an application for that. That issue you have not raised there.
It's a misconceived application, my lord. No, can this prayer be allowed?
Where is the section 5 application?
My lord. Now, section 5 is page 65, my lord. Page 65. Start from page 65. And if my lord turns, my lord sees page 40, the petitioner is the bona fide tenant. He
That
claims
is their,
to be.
that is their case. They
My
have
lord, the
to,
prayer, my lord,
they
the
have to
association, KMRA.
they have to prove there in that case. That has to be
But
proved
in
by
this
way of
law-
evidence.
My lord, in order 21.
All right.
File a-
Order 21 is all disputes, right, title, and
Independent
interest
right,
has to be
independent
decided.
right. What the prayer is, my lord. My lord, see the prayer.
Yes.
Page 59.
Yes, on the prayer of the learned advocate for the petitioner.
For time for the petitioner in this matter.
Yes.
Are the opposite parties?
Yes.
Are the opposite parties filed a suit for declaration along with eviction, khas possession, and permanent injunction against the petitioner at the lower court below, before the learned 13th bench in the Civil Court, Calcutta.
Yes.
Agreed by the impugned order dated 3rd December 2024. But at the threshold, the petitioners, they filed an application under Order 7, Rule 11D of the Civil Procedure Code for rejection of plaint on the ground, my lord, that the suit is barred by limitation. My lord,
Barred by limitation.
the suit is barred by limitation, my lord. But the cause of action arose in the year 2006. In the year 2006, after expiry of 5 years, the cause of action arose in the year 2006. They ought to have filed the suit within 2018. But in these 12 years, no action was taken by the opposite parties. On 29 January 2024, they took the first step. And for them, 12 years, there were no steps taken from their side. So to fulfill the personal vendetta, and to camouflage the mysteries, they filed the suit frivolously. And such suits are liable to be dismissed at the threshold, so that the valuable time of the court is not wasted, my lord.
Have you set up a case of adverse position, madam?
And in the letter it was given. In the letter we have given in the note.
Adverse position.
Adverse position, we have given that in the letter notice. But in the rejection of plaint, my lord, we have taken statutory provisions strictly.
So that will be decided. Your case of adverse position, when you set up that case of adverse position, if their title stands extinguished, then the question comes.
In the rejection of plaint, my lord, we have not taken the rejection of plaint. We have completely focused on the statutory provisions, my lord.
Yes, statutory provision. Which provision? Show me that.
7 Rule 11D. Of the
Yes, 11D bar. Under what provision it is barred?
Order 7 Rule 11D of the Civil Procedure Code, my
Order
lord.
7 Rule 11D, I appreciate. Suit is barred from the statements made in the plaint to be barred by any law. Under which law?
Of limitation, my lord.
Show me which article of the Limitation Act stands attracted here. Which article of the Limitation Act stands attracted here?
My lord, kindly come to paragraph. My lord,
Yes.
the avertments made in the plaint, my lord.
Yes,
Kindly
which provision of which article of the Limitation Act stands attracted here? Limitation Act. Which article of the Limitation Act?
My lord, it's
Which article?
Article 133 of the limitation.
33. What does 133 say?
My lord.
That's the residuary clause. Yes. Yes, madam. Take the Limitation Act. Under which article of the Limitation Act the suit is barred?
Section 3, my lord.
Section 3, court has to look into. Which article of the Limitation Act the suit is barred? Because the period of limitation has been set out in the articles.
Article.
Nature of the suit.
12 years for suit.
12 years
from the date of cause of action. But Article 12, my lord, has specified certain periods for suit.
See Article
Section
12. Says that.
In computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. In computing the period of limitation.
That is Section 12.
Section 12, my lord.
Section 12 is how limitation will be computed. What's the period of limitation for a suit of this nature?
12 years, my lord.
From which article says so?
Lord,
You have said Article 123 or 133.
Article 65, my lord. Article 65, my lord. Visitation.
Please check up 65. What does it say? There are two articles.
In a suit for, yes, my lord, in a suit for declaration of title and possession based on title, both for relief of declaration and for relief of possession, limitation period applicable would be under Article 65, where the suit is by a remainder man or a device, the possession of the defendant shall be deemed to become adverse only when the estate of the remainder man, reversioner or devisee falls into the
What are
possession.
you seeing? That articles, please place the article. Articles is the tabular form.
Yes, madam. Tabular form.
Wait a minute. Please give me the book. I will find it out for you. এটা দেখান tabular chart. Yes.
Article 65, in a suit for declaration of title and possession based on title, both for relief of declaration, for relief of possession, limitation period would be that under Article 65.
Madam, you are placing that. Please place the tabular chart, that italics portion. দেখান
The
নি ওটা?
limitation period applicable would be that.
You are place. ওটা দেখা দিন। Please give me the book. I will put a tick mark. টিক মার্কটা দিয়ে দিয়েছে, ওইখানটা দেখতে হবে।
For possession of immovable properties or any interest therein, 12 years when the possession of the defendant becomes adverse to the plaintiff.
Yes. So 12 years will run from the date when the possession becomes adverse. So that's the disputed question of fact, because we have to set up a case of adverse possession in your written statement. So written statement has to be considered. So the basic principle is, from the averments made in the plaint, it cannot be looked into. You have to set out a case of adverse possession. Only then, if you succeed, at the time of trial, suit may be dismissed. Ashok, give me the book. This application.
which I have referred on first issue. But